Yesterday I mentioned this matter, my lord. Justice Sina granted us leave and directed the matter to appear tomorrow. Extremely urgent tender matter, my lord. Financial bid has been opened. My lord, X is giving to his right hand Y. The tender, he is not eligible. Railway is giving it to RVNL, where RVNL is not eligible to participate in the tender. My lord, work order will be issued, my lord, as per our information tomorrow. Kindly let it appear tomorrow, my lord. We have already served copy through email by Lord physically. Leave also granted for tomorrow. I shall issue another notice, Lord. Kindly, Lord. Otherwise, the entire matter will become infructuous. Already, it's filed with the leave of Justice
You
Sinha.
have participated in the tender.
I had participated. I am the L2. I am the L2. Under tender, if L1 goes, I will get the tender. They are absolutely prima facie, expressly ineligible. But since it's rail's tender, they are giving to RBNL.
Is there a bar?
No, they have to qualify. The qualifying criteria says that they have to produce the a credential certificate of a completed project, a completion certificate. They produced another certificate which is not a completion certificate, a performance certificate, which is absolutely prima facie feeling, Lord. I will take only 3 minutes to, Lord, place the case, Lord. Absolutely, Lord, on the face of it, it's, Lord, they are not eligible. Despite that, we wrote a letter. There's a provision in the tender that they can withdraw the declaration of L1. We informed them that this is the anomaly. Despite that, they are issuing work order. The matter would become infructuous, my lord. Kindly, before vacation, we'll suffer. Kindly, my lord. Tomorrow, let it appear, my lord. I shall issue notice today with email. Ensure they are made. I'm so,
My lord,
An urgent application, Lordship. This is a demolition notice I am facing, my lord. By tomorrow, the demolition will be effected.
Claim damages. If the demolition is affected, you have a sanction plan.
I have a sanction.
You have a sanction plan.
I do have a sanction plan. They have, in the notice, they have not indicated the portions which are to be demolished.
Show me the sanction plan.
My lord, sanction plan's copy is annexed. P2 is there, Lordship. I'm sorry, my lord. This is I have to give the legible copy. Lordship, this is the sanction plan.
Sanction plan is for?
This is for construction of building G+2.
How many floors?
G+2. Lordship, there probably there is one extra floor.
Propose G+2 storied building.
Yes.
How many floors are there?
Lordship, extra one floor, my instruction.
So let that go.
My lord, that has to be indicated, my lord. That why? Because there is a scheme of the under the corporation. 177 is there, and
177 doesn't entitle you to get regularization for the entire floor. Sorry, sir.
Lordship, kindly take it up and Lordship kindly pass the order. Let them indicate that.
Where is the notice? I will not unnecessarily burden this.
Next year, P4 is the notice.
Page.
And there is the regulation which has been effected, my lord, for regularization. So earlier the regulation was not in place. Now regulation has been effected, my lord. So notice does not indicate which portions is illegal, unauthorized. Nothing.
This has been going on, nothing since 2023. Nothing, no urgency.
my lord, very urgent matter.
No urgency.
Very urgent matter.
2023.
That was the show cause, my lord.
Show cause notice, sir. So no urgency. Yes.
My lord, very urgent matter. Protection.
Otherwise, demolition.
No. Let it be demolished. You seek damages.
14.
Let it be demolished. Nothing illegal will be demolished. Only nothing which is in accordance with law will be demolished. Only the illegal portion will be demolished.
That portion has not been indicated.
Sir, we will see that. No urgency.
My lord,
no urgency, sir. No urgency. File it. Yes.
It's a very urgent matter. Praying for interim protection of the responding finance company who has taken forcefully my possession. My property is not the subject matter of mortgage, but using the order passed by the learned Chief Judicial Magistrate Howrah, my property, the property which to be taken for possession would be 977 Sabik Dag number. My Dag number is 981. They haven't identified the property and they are forcefully.
Surface proceedings.
Yeah, it is in for the court of 14.
Go before the court.
My lord, may I mention?
My lord,
from the list of court 14.
DIT.
My lord, the pension account of the senior citizen has been frozen without assigning any reason.
Very good. When was it frozen?
My lord,
When was it frozen?
it was since August 24, my lord.
Wait, no,
My lord, I am facing the difficulty.
no urgency. Yes.
Two times I mentioned this matter for unauthorized construction over the building.
Unauthorized construction, the law will take its own course, sir.
Milord, may I mention, Milord, item number?
Give your slip. Give your slip. Give your mentioning slip. Give your mentioning slip. Give your mentioning slip.
Lordship, I may be permitted to mention a matter.
Which
was to-
roster? My roster?
No, Your Lordship, court number 14.
Yes, tell me.
It was to be taken up today, last Monday. Justice Sinha had agreed to take up the matter today.
Sir, I can't help
Not
it.
No, she's not sitting today,
Yes.
and it is very urgent. Your Lordship had passed an order, say, asking the respondents to furnish their opposition within 7 days, and for us to respond within 3 days. Exchange of affidavits is complete. Lordship will please
Very good.
take
I
up the
can't
matter.
Can't take it today.
May I have your lordship's
Lordship, tomorrow, 2 p.m.
No way.
Item number 192 of your lordship. Urgent is that I am a single mother. Now I am not getting the birth certificate indicating that I am a single mother.
Give your,
Because of my lord.
give your.
Milord,
The law is
mention, Milord.
not tomorrow.
What
What is the urgency?
urgency is that the admission of my daughter is going on. Otherwise, she will suffer that. The court will be closed. My lord, it is pending since a long time, lordship.
You have served notice?
I will serve notice. lordship.
What do you mean I will serve notice? Why didn't you serve the notice? Before mentioning what is the procedure,
I should have served.
then why didn't you do it?
I will serve it today. So I undertake to serve it. Right?
Give it back.
Milord, may I mention, Milord,
My lord,
Serve the notice. We'll see on Friday.
may I mention
My lord.
item number 3 of the Milord urgent determination of Milord Justice Milord Amrita Sinha. Milord, considering the urgency, her ladyship had already granted leave to Milord moved yesterday to move the matter.
What is the matter, sir?
Urgency is Milord a proceeding under section 10 of the Highways Act. Milord was initiated.
Very
Now,
good.
Milord, they Milord directed the highway authority directed the block land and land reforms officer to Milord demarcate the plot of land and to see whether there is any encroachment. No notice demarcation done. No Milord opportunity was given to me to file Milord objection. Now, Milord, in the meantime, final order has been passed. Final order has been communicated. I have preferred a statutory appeal. There is a statutory appeal before the district magistrate. Now, district magistrate has fixed the matter sometimes in September. Now, Milord, tomorrow is the date for demolition. I cannot get any interim protection from the appellate authority.
Move an application before the district magistrate.
Milord,
My lord,
tomorrow,
may I be
Milord, considering the
Move an application
may I
before
be
the district.
permitted to
Milord, there is no such, Milord,
You
considering the
move an application. If there is any unauthorized construction, encroachment, no urgency.
My lord,
there is,
upon
Milord,
notice, my lord, I am
this is already
upon
granted.
notice.
Give, Milord, kindly
Nothing
appreciate.
doing, sir. Sorry.
My lord, upon notice, I am mentioning, my lord, this is matter relates to illegal construction, my lord. The petitioner is a cancer patient, my lord. His own common wall has been demolished, my lord.
Very good.
My lord, this is my inclusion in the daily list, my lord.
Give your,
Under
Upon
my lord, I
give your,
Court number 14, my
Yes.
lord, Tuesday I mentioned the matter. His lordship asked me to file it and get the number and mention today. My lord, what is the notice? Sale notice was issued. I own the 3 properties. Property, my value was, my lord, correct. The residential property, my lord, they took the under value. That's why, my lord, I objected before the authority. Why put the under value, my lord?
so what is the urgency, sir?
Sale notice was already issued, my lord. 28 is date to say, my lord, sell the property, my property.
Sale notice has been issued. Valuation has been done, not as per your wishes, I guess. That's the urgency. No urgency. Yes.
I would not keep from your lordship that is estimation of and I have made an application for granting permission to organize a mela, which is scheduled to be held on 24th. Till today, no permission has been granted by the district magistrate.
Why have you come here?
This is the Justice, Honorable Justice Amrita Sinha.
When is the Mela?
It Uttar Dinajpur, Islampur. It is
When is the Mela?
24th,
24th.
my lord.
What Mela is this?
Trade and educational fair. I am organizing for the last 10 years. I have the certificate to that effect. I am organizing thing. I have made application that has not yet been granted.
So why have you moved at the last minute?
But I am of the
When was the rejection?
no rejection.
Then why have you come here?
But I have made an application on 6th May 2025 till today. That has not been considered. No order has been
After
passed.
6th May, what were you doing?
But I am waiting that they will grant me the permission.
So you have come here.
Yes, my lord.
Sorry, sir.
But there is
The kind leave,
Sorry,
my
sir.
item number
Pursue with the.
Well, item number 138 of your lordship's list, my lord. This is in respect to a water connection, my lord. Well, I have applied for the water connection. The KMC is not giving, my lord. The only problem they are asking for 85 plan sanction, whether I have a sanction or not. That is not connected to water, getting a new water connection. That is the only preamble in this hot weather, my lord.
Give your
One
slip.
period will have
my
served the
lord's
notice, my lord, both the parties.
My lord,
Give your slip.
my lord,
Will see.
may I have my lord's leave to mention, my lord, this is a
Give your
matter.
slip. What is the matter?
For inclusion of.
Give the slip.
138.
My lord, may I be permitted to mention one matter, my lord? May I be permitted to mention one matter, my lord?
What is the
My
matter?
lord, this is for the inclusion and
Give your
upgradation.
slip. Give your slip.
Your lordship's leave to mention one item. It's appearing as item number 228 in your lordship's list, my lord. My lord, under 400 subsection 1, an order has been passed. Now, my lord, there is a statutory time period within which I can prefer an appeal once that order is communicated to me. My lord, I have filed this writ petition because they have not communicated anything. Now, yesterday, my lord, I have received a notice they will be demolishing it tomorrow. I have a sanction plan, my lord, valid sanction plan for the entire construction, my lord.
Very
There
good.
is no precise, no deviation which has been cited, my lord.
Give your slip. We'll see that.
My lord, may I come back? My
Give
lord?
your slip, sir. We will see that.
May I have my lord's leave to mention, my lord, this is a matter pertaining to my lord Justice Sinha, my lord.
Yes.
My lord, this is a matter related to quashing of lookout circular, my lord.
Ah.
There is an interim order passed by my lord Justice Sinha, whereby my lord Justice.
Pushing of lookout circular, nothing doing.
My lord, the
Nothing
urgency is that
doing.
I have filed an application
I
praying for my lord
rejected,
traveling, my lord. There is an
Rejected.
interim order pertaining to that, my lord. My
Rejected.
lord,
I'm
I have
not
to be
getting on
traveling
your
to
LOCs.
a economic convention, my lord.
Very good.
Kindly, my lord.
Very good. Don't travel.
My lord,
You
kindly,
don't
I
have
have
to
been
travel.
invited, my lord. I have been
Sorry,
invited.
sir.
My lord Justice has
Invitation
given
next time.
given
I
me
am
leave to
not-
move the matter day
I
after tomorrow.
Rejected, heard, rejected. Next.
This matter is appearing in court number 14,
Grateful,
my lord,
Lord.
item number 63, my lord. The urgency is, my lord, there is a housing board matter, my lord, with regard to the association. The election is going to take place, my lord, on 25th May, my lord, and the court will be in a holiday mode, my lord. All I am visiting, my lord, if the matter can be taken up, because this matter, this writ.
Give your slip. We'll see that.
Very well.
You are mentioning upon notice, my lord, this was filed in March, my lord, it is yet to appear in the daily list. The urgency is that, my lord, the private respondent has constructed additional floors.
Give your slip, sir.
Your lordship,
The urgency is that.
Give your slip. Unauthorized construction. There's no urgency.
may I have your lordship indulgence? This is an equitable urgency. The petitioner is a class 8 student. The marriage of the parents have been resolved all along. The petitioner was using the maiden's mother's name. However, while applying for the CBSE, the school insisted that the name of the birth certificate will applicable to the surname of the father. We applied to the municipality. There is an order passed on 5th, communicated on 10th. Now the enrollment of CBSE will start. All along the name was of the mother's name only. Suddenly, because of the birth certificate, the school is insisting or revising the entire records.
So you go before the CBSE, get the change run.
We have put in we have gone to the municipality to registrar for revision of the certificate. They have passed an order which has communicated and declined, saying no power. I am only praying if it can be taken up. It's
We'll see that. Give your.
my lord, kindly leave to mention matter, my lord, for the relates to my lord the unauthorized construction. My lord,
Give the slip, sir. Give the slip.
So 140 of the days list, Lordship, 296 pensioners are not receiving their pension since December, Lordship.
Give your slip.
Lordship, mentioning was allowed, Lordship, on Thursday and Monday, Lordship, not being.
Give your slip, sir. We'll see that. You are getting provisional pension.
No. Lordship, running pension discontinued from the month of
Okay.
December for 296. All the pensioners of
Give the slip.
all the pensioners.
Yes.
Lord, with lot of hesitancy. Milord, I have to comply with an order. There's a defreezing order which Lordship Sinha, Milord, has recalled. Now the signatories have to be changed.
My court.
Lordship,
This is Sinha's court.
Justice Sinha's court. Milord.
Tell me.
Yes, there's a defreezing order which,
Yes.
Milord, without adding the party, we were there. Milord, the person who was the signatory, the Birla group, they were removed on the basis of a board resolution, but they still
Sir,
remain.
tell me the urgency. What
The
is the
urgency
urgency?
is to comply with the order.
Sorry,
I
sir.
have to, Milord, only, Milord, need a, Milord, direction from your lordship to change the signatory, Milord. That's all.
Sorry.
My lord,
That's all, Milord.
Sorry.
my lord, may I
Lord.
pray?
May I have my lord leave to mention item number 195 of today's list file.
Yes.
Corporation has increased the annual valuation on basis of a complaint lodged by a third party.
Annual valuation, property tax.
Property tax.
Go before the tribunal. Why don't you go before the tribunal?
Thereafter, they have admitted that there's no property is not being used for commercial purpose. They have approached the tribunal. Tribunal has not entertained the appeal.
my lord, we have come up before and we have issued the attachment notice. My
Oh, very good.
My lord,
No urgency.
my lord, under,
No urgency. Take it.
my
No
lord,
urgency at all.
under compelling circumstances, I'm
Give it back. No urgency.
my lord, may I mentioning a matter of
Yes,
the
madam.
original side, my lord.
Yes.
The petitioners are two schools, La Martinia School for Boys and Girls. My lord, it has been graded as a heritage building, so we cannot touch it without taking permission of the concerned respondent. My lord, the school is in an extremely dilapidated condition. Urgent repair work is necessitated at
So
the
you
current
thought of
moment,
doing
my
it
lord.
today?
My lord, tomorrow, if lordship takes up original site, if it may be taken up tomorrow, my lord, because the lives of the students are at stake, my lord, kindly considers that, lordship. My lord, the
Please.
school has,
Nothing becomes urgent in a day. Has the roof fallen?
my lord, the roof, the portion of the roof is damaged, my lord, the staircase is damaged, the
Madam,
washrooms
please.
are damaged.
Did it get damaged yesterday?
No, lordship, it has, we filed the writ petition yesterday,
So
my
what
lord.
is the urgency?
Urgency, lordship, is that the school has closed for summer vacation. I'm only getting this period of time to cause the maintenance work. After that school reopens, my lord, it will be difficult for me to cause the maintenance work.
This is absolutely. You give your slip, we'll see that.
My lord, may I praying, my lord, leave to move to urgent matter. My lord, what happened? The petitioners are participate in a selection process of Group C and Group D of SSC, my lord. Some of the illegal appointees got appointment, and by virtue of the Supreme Court order and by virtue of division bench of this honorable court order, their appointment is, my lord, set aside. Thereafter, my lord, Labor Department introduced a scheme that those who lost in the appointment by virtue of court order, they will get some amount of 25,000 and 20,000. My lord, the petitioner are also entitled to get the, my lord, same amount, and the same scheme is introduced by on 15 May 2025.
Justice Sinha's board?
Yes, my lord.
No urgency.
My lord, kindly grant leave, my lord, on reopening date, my lord.
Give me the dates.
My lord, date is, my lord.
Wait a minute. Scheme date.
Scheme date is introduced in 15 May 2025, this month, my lord, and with effect from it is come into force retrospectively on 1st May 2020.
No urgency.
And my lord, this
After all,
last of this
urgency, madam.
31st, my lord, they will get the
No urgency, madam.
lord,
Yes.
may I permit to mention one matter for upgradation, my lord. My lord,
Upgradation, give your slip.
number.
Give your slip. Yes. एक एयरकॉन वाला ना ये, हाँ ये दे दो, ये फाइल दे दो मुझे, ये लगा दो, ये 3 बजे रख दो, ठीक है, 3 o'clock. After I finish the division bench, के बाद ये क्या है? Nothing. ये कर. It is clarified that the respondent corporation is at liberty to proceed with the ongoing tender process. However, the formal allotment of the toilet facilities located at Toliganj Metro Station and Arka Fatak pursuant to the said tender shall only take effect upon expiry of the period up to which the petitioner has deposited the royalty charges. Post 4th the quarter 2026. With the above direction, the present petition stands disposed of.
Urgent photostat copy. Urgent photostat certificate copy.
Sorry?
Urgent photostat certificate copy.
It will be uploaded. Upload करा दो.
ठीक है
21st না
টেন্ডার কন্টিনিউ করবে কিন্তু ওইটা এফেক্ট দেবে না
because of urgency I had to do this.
We're extremely grateful, lordship.
It doesn't look like.
So they're grateful also.
Still is complaining.
Huge pressure and his judgment is very difficult to one day time. Grateful.
I'm also grateful.
The only difficulty, Mr. Naik, in this was you had withdrawn your complaint.
On behalf of the petitioner, your lordship, I'm led by Mr. Banerjee. Kindly translate.
Extension, my lord. The order was there on 25th of November 2024. So only 16th of
16th of April, extend right file last week.
It was granted on 25th November 24, extended last on 16th of April. And it's expiring today.
No,
And
the
Affidavit has been filed.
expiring in the end of May. And the reply also, my lord, if I may say.
You are for?
Private respondent.
For the corporation, lordship.
No, lordship,
Yes,
you can
filed
keep it
a
any day.
Where's the affidavit?
No, lord, we have filed a report, lordship.
You filed your report?
Yes.
You filed?
Yes, we filed a, we filed a reply.
My humble submission is that in absence of the regular court, the petitioner.
So that every time he.
Petitioner mentioned before the judge court, and then they got implemented. The page number is last page.
We have mentioned it on notice.
The order
No, my lord, that was on November 24. Then my lord, Justice Chanda heard it.
Demolition order passed by the corporation is the common portion. We are residing in the ground floor. There is a 4 flat, 4 flat occupied by the petitioner, 2 flats, 7 and 8. And other also garage space flat with the So, there is the common portion, the rooftop we are made out by the petitioner, corporation demolition order passed. I mean, page number 81.
I don't mind it.
Just a minute, Mr. Banerjee.
The agreed person by order such and such against the order to municipal corporation to go to the tribunal within the stipulated period. It is a appealable order. Tribunal is the functioning order. This order cannot be challenged before this writ court. This court has no jurisdiction. It is an appealable order. So, petitioner may avail to the appeal court by challenging this order. Your lordship may give a liberty if there is any delay, but this is not a maintainable in the law.
Affidavit in opposition filed on behalf of the respondent number 7 and 8 is taken on record. Exception to the same is also filed by the petitioner. The same is also taken on record. Let this matter be listed for.
What is silhouette?
Pleadings are complete, right? For hearing. When is the interim order expiring?
End of May, 31st of May.
And when was the interim order granted?
25th of November 2024, extended last in
The
April.
interim order granted by order dated 25th November 2024 and has been extended
In April.
and has been
On 15th of April.
periodically extended. Is extended further for a period of 8 weeks. Let this matter be listed on 25th June,
Yes, ma'am, whenever.
8 weeks.
25th.
But in the meantime, my lord, I am praying humble submission for past interim order. Because my lord, the rooftop, my lord, made by the petitioner for arranging a different type of event. My lord, I came to know for build up the relationship with the woman, my lord, the petitioner, my lord, the made a rooftop. Thereafter, my lord, by the my lord, by the power of patronage, my lord, got anticipated people in the rape case.
Sir,
So, my lord,
all this is not,
they also organize different organized.
all that is not relevant. We will decide.
But resident to not to make any program before the room, it is common property, 200 people, small space.
I cannot stop somebody from organizing dinner.
Property. It is a
Go
common
to the
property.
police. Go to the police if you are being aggrieved.
Give a liberty, police also not.
Why should I give you liberty?
There is a
Do I need to give any liberty to somebody to approach police authorities?
very influential person, my lord. Police
What?
also not be taking any step.
You also become influential, then maybe something will happen.
Thereafter, several complaints.
Sir, we will hear the matter on 25th.
Especially fifth.
What do you mean specially fixed?
Extending the interim order, my lord, knowing fully all that is not a maintenance.
Sir, just because your clients are here doesn't mean you will
No, my lord, no.
plead beyond the pleadings.
Two lady client, my lord, they are suffering, my lord. They are suffering, my lord.
So,
200 people.
so keep your horses. You don't have to unnecessarily impress people. We will hear it. We will hear it. We have given a date, we'll hear it.
Any day, my lord. Any day, my lord, but he
We have already given a date. What is wrong with you? You don't understand.
We are suffering, my lord. Every day, my lord, 200 people, my lord, went to the roof. There is a two-story building.
You have remedies in law. Exercise it.
Grateful.
Item number 3. June, na?
I am for the petition, my lord. My lord, on 2nd May, your lordship was pleased to extend the time to file opposition, my lord. Till date, my lord, I have not received any copy of the opposition.
Yes, Mr. Mukherjee.
It has been ready, but my lord, what happened that my lord, I will kindly extend last chance for 1 week.
You appear for KMC. Mr. Mukherjee, Devjit Mukherjee seeks and is granted further time of 1 week to file his affidavit in opposition. Reply to the same, if any, within 1 week thereafter. List on. Is there any urgency here?
He is already enjoying the interim order.
Which is till
tomorrow.
interim order is till tomorrow.
Till day after tomorrow, my lord.
All right.
Your lordship extended interim order on 2nd for 3 weeks.
All right. List on 25th of June. Interim order granted. Interim order is further extended for a period of 6 weeks. Further. 6 weeks. Or until further order, whichever is earlier.
Great.
Till
6.
Okay. Would I beg to appear on behalf of the petition?
Yes.
Well, we have challenged the proceedings under section 400 subsection 8, my lord. But there is an subsisting interim order in the matter, my lord, which expired yesterday, my lord. We had mentioned this on Monday before your lordship, my lord. But a report has been filed by the corporation and we have ready with the exception to the report, my lord. If your lordship can be pleased enough, my lord, to extend the interim order for a limited period and hear out the matter. Exception to the report. Arekta copy de, Devjit da ke de.
Yes, Mr. Ghosh.
My lord, initially he filed this present deed petition when he took an action, my lord, for my lord, raising an unauthorized construction to the extent of 3,000 square feet on the roof. And then, my lord, he immediately came to the court when he started demolition. Then obtained an interim order. Court, my lord, asked us to submit a report. We have given a detailed report regarding the actions and the constructions made. Now, my lord, so far as this writ petition is concerned, immediate submission has become infructuous. Because after the report being filed, he has filed a substantive writ petition questioning the said report. Therefore, my lord, that application is with me, my lord, 9884 of 2025. Therefore, my lord, this writ petition, the present writ petition, in which the interim order is granted.
I'll revert to this.
You have filed another writ petition.
In the report, they have stated that in respect of one portion of the building, they have initiated proceedings under 400 subsection 1. If your lordship kindly takes up the report. Now, my lord, why we have come in that writ petition? That writ petition we have challenged, my lord, they were not giving the certified copy of the order. Now, unless the certified copy of the order is given to me, my lord, I cannot prefer the statutory appeal.
It has got no connection with because 408, my lord, 400. He has, my lord, jumbled the issue to, my lord, confuse the honorable court. My lord, this is, my lord, two aspects
kindly
there.
takes up the report filed by Mr. Ghosh, my lord. Kindly takes up the report.
My lord, 400 subjects. Your lordship kindly appreciate that. I'm just making it clear. So far as the roof part is concerned, action has been taken as 408. But so far as other constructions in the building, which one the sanctioned part, there he made certain unauthorized constructions. So far as those portions are concerned, 400 subsection 8, that power is exercised by the municipal commission has been undertaken. That is there. That has got no connection. We are not saying anything about the 400 subsection 1 part. But we are now concerning about the 400 subsection. He has opened the case in saying before lordship, my lord, that corporation has taken under section 400 subsection 8. Therefore, that one of the portions he has submitted a report regarding court in these particular proceedings, my lord, recorded and an order, my lord, directing us to submit report 408 is concerned. We have submitted. Now, my lord, so far as that application is concerned, in my response submission has got nothing to do right now because of filing a substantive writ petition against the challenging that report concerning the 408 order. And my lord, so far as that, my lord, the 401 is concerned, we are not, my lord, concerned about that. Is, my lord, separate issue. He has a right to prefer an appeal. He will go and appeal. That is in respect of different parts of the building. Therefore, he cannot join the issue to in a particular way.
Yes, may I reply, my lord?
This is the repetition 9884 of 2025. Report this court.
Yes. My lord, probably the police authorities are overzealous in the matter, my lord. With utmost respect, my lord, kindly takes up the report, my lord, once filed by Mr. Ghosh, my lord. My lord, kindly takes up the second page of the report.
Yes.
My lord, I'm reading from the paragraph which starts from in view of the said decision stroke resolution. My lord, it's in the near the end portion, my lord. Your lordship has got it, my lord. In view of the said decision stroke resolution of the MIC dated 13/12/2024, such an action for demolition of the unauthorized structure were undertaken, but since the Honorable Court by its order dated 16/1/2025 directed the corporation not to make further demolition of the structure of the said premises, the KMC stopped the progress of the demolition work. Save and except the above structure under order of demolition of the MIC dated 13/12/2024, the petitioner has also made certain other unauthorized construction works in other areas of the building for which a demolition proceeding under section 400 subsection 1 of the KMC Act 1980 was initiated to the intimation and information to the person responsible. The demolition proceeding under the said section has already been conducted and completed by passing an order which is now pending for approval by the MIC. My second writ petition, my lord, which I have filed before this honorable court, is for procuring of a certified copy of the order under 400 subsection 1. And if your lordship kindly sees what I have challenged in this writ petition, kindly takes up page 64 of your lordship's brief, my lord.
Yes.
My lord, this 64 of your lordship's brief, my lord. My lord,
Page 64.
my lord, Mr. Chakraborty is leading me.
Yes.
Lord, page 64 is under challenge in the present writ petition.
Yes.
The subsequent writ is only to obtain the document. Lord, kindly come to 64. This is a case of unauthorized construction. Look, this is an order under 400 subsection 8. This is a case of unauthorized construction as reported by the concerned borough. It is understood that the person responsible constructed one additional floor, erection of tin shed structure over existing 6-story building without sanction. Lord, kindly pause here for a moment, Lord. Only one information to your lordships. The building is, Lord, G+5 storied, and there is no additional construction thereof. There is a planned sanction. Then, accordingly, the concerned borough issued stop work notice on so-and-so 30th October 2024, along with police information sent to Bhawanipur police station. Department also placed matter to take action under section 400 of KMC along with this case map and infringement of statement. The alleged construction infringes several building rules, including rules under 133, 134. DG building is ordered to take action under 400 subsection 8. Moreover, the said unauthorized construction, if allowed to stand, may collapse at any moment at time, leading to accident resulting in loss of human lives and properties, and may also create several hazards like fire hazards and environmental hazards. Considering the gravity of the situation, safety of public in general, department recommends demolition of the unauthorized structure. Now, kindly come to take one page ahead, page 63. Kindly take page 63 once. This order was passed on 27/11/2024. We did not have a copy. Now, kindly have a look at page 63. On 12th December, we wrote to them. This is to inform you that above premises were constructed since 1973. Ground plus fifth floor, according to your sanction plan, white number 164 dated 26 June 1973, D4 copy of the said sanction plan has been enclosed for your kind information. Please, presently we have done repairing of the said building. Please note that we have not done any further construction at the said premises. This was with them. They came to demolish. My lord will kindly take the report submitted by the corporation once. Report Lord, in the report what they say, Lord, they are saying that there is some tin shed construction at the top of the building which they want to demolish. They never say, the report doesn't say that the construction is beyond 6 floors. The plan is for G+5. The construction is not even beyond 1 floor. There is no additional construction. It is a.
How can you make that statement? The report itself says that you have constructed above the 5th floor.
No, not at all. It doesn't say. May I show it to your lordship, my lord? Perhaps a wrong impression has been given to your lordship. Kindly come to the report, my lord. I'm sorry, my lord. Kindly take the report once.
Yes.
As per my instructions, my lord, that there is no additional construction. It is G+.
Page 64.
Page 64. Kindly take. What
does it say? It's a case of unauthorized construction reported by the concerned.
It is understood that a person responsible constructed additional floor erection of tin set over existing 6-story building without sanction. Now kindly take the report submitted by them.
Yes.
The report submitted by them, kindly have a look at it. My lord has the kindly has the report, my lord, with your lordship, my lord.
Yes.
Now, kindly come to the paragraph starts with keeping in view. My lord has kindly got that.
Yes.
Keeping in view the said allegations of KMC as stated follows. While it is correct, a building plan was sanctioned white so and so number dated 73 dated 26 June 73 for construction of a G+ mezzanine plus 5-story building. But the construction had been made up to G+ mezzanine plus 4. They are making a story that although I had a plan for 6-story, I initially constructed 5-story, then I am now constructing 1-story.
Oh, you are reading it wrong. Come to the first page.
No, I'm reading it not again for your lordship. Keeping in view.
Plus, read the first page, sir. Come to the report, the first.
Yes, first page. I'm in the first page, my lord.
Keeping in view the said allegation of the KMC.
Yes.
While it is correct, a building plan was sanctioned in 73 for construction of G+ mezzanine plus 5-story building. But the construction was made up to G+ mezzanine plus 4.
Yes.
All right.
Yes.
The building plan was sanctioned stood lapse by flux of time. It is needless to mention that the said building plan sanctioned so and so and the building rule so and so subsequently came in force. There is no scope so and so. Now read the last line. But the person responsible was found to be continuing with the construction work for an additional floor over the roof, and ultimately the structure was covered by corrugated tin shed. The total structure covering the entire roof was approximately so and so. The structure as raised come within the purview of definition of building so and so. You have made the construction has been made without permission, is huge and humongous, voluminous. The height of the building as raised is not permissible under the present act and the building rule. Be that it may, the concerned higher authority, upon perusing the file and also in consideration of the huge construction, decided to take action under 408 so and so. So, sir, the unauthorized construction is on the roof level where you have constructed the tin shed.
May I, if Malakal allows me. Lord, their case, with my limited ability, what I could understand is the plan is for G+ mezzanine plus 5. There is a plan. They say I did not construct the 6th floor initially.
Yes.
Their case is now I am constructing the 6th floor.
All right. Let us assume that you are constructing the 6th floor. Now you are constructing.
Now my case is that the 6th floor as it is was already there with tin shed. We have only repaired now. That is my letter at page 63. There is not even 1 inch additional construction. That's a reply at page 63. Kindly take note.
That is your saying. I can't go by what your reply is.
Kindly come to page 63. 63 of the report.
Go by the report of the department.
No, they don't say that I have constructed 1 additional floor. They are saying I have now constructed.
Yes.
It's not that it's beyond the plan. They are saying their story is plan was there.
Mr. Ghosh, I make it clear, my lord. I have said, my lord, categorically, it's made it clear the G+ mezzanine plus 5-story was sanctioned in 1973.
That's right.
Plan which was sanctioned under this was under the old act and the old rules.
Right.
That was in 1951 act and the civil schedule 16 framed under the 1951 act as a sanction.
Right.
Now that, my lord, any plan sanction is, my lord, life under the law and the rules is 10 years on extension of 5 years.
Right.
Therefore, it should last, my lord, long before. It was all through also in the assessment record, the G+5 story building.
Assessment record.
G+4 story building.
G+5.
G+4. It was sanctioned, but constructed G+4. But one of
No, that is not his, Mr. You see your report.
Yes.
G plus mezzanine plus 5-story building.
Yes.
that is the sanction.
Yes.
And my lord, my
Construction
conclusion,
is
but the
G
construction has been made up to G plus mezzanine plus 4-story.
Right.
Therefore, 5-story was not there. That 5-story, my lord, which has come now on detection that they have now made the construction. Now all this story, my lord, comes all the time that I was just making repair. Even Lordship may send anyone, if Even Lordship does not believe us, that whether the structure which has been raised now, glass panel with, my lord, the brick walls and all these things are there, about 3,000 square feet, whether it's a new one or old one. This is, my lord, plea they are taking, my lord, that because they cannot, my lord, get the sanction right now.
Is it believable?
Upper floors, my lord, under the present rule, present law.
Yes.
Therefore, my lord, they have
But is
taken recourse to that, my lord, course.
Lord, is it believable somebody in Calcutta will have a plan for G+5-story, will not construct and wait? And now after 50 years, the corporation will come that you are now constructing.
Why not?
Believable.
Lord, kindly,
Absolutely believable. Why not?
Lord, I have my case from the day one was that it is already constructed in 1973. Let him show that the assessment book says it's not G+6. He has not annexed that in his report.
Where is the assessment book? Have you annexed?
Kindly
Plan-
have a look at my plan.
Page 52.
Page 52.
We are not going on the plan, sir. Plan is already there.
Yes.
We are not going by the plan. Are you paying the property tax for the 5th floor? Since when?
Anybody could say from the
Very well. They could have produced it. I'll just inquire. Till then, may I just show you the rest of the portion of the report? Kindly come to the report again.
Yes.
So their cases, I am now making the 5th floor.
Yes.
আমরা 5th floor assessment হয়েছে না. Now kindly come to internal page 2 note of the report. Your lordship note, the sentence starts with without obtaining. Maharaj kindly got that? Without. Lord, I'm so sorry. Lord, I'm so sorry.
Where are you reading?
Lord, may I now kindly come to page 1? May I place it from the portion that I wanted to show? It will be easier because otherwise from the middle portion it will be difficult. While it is correct, a building plan was sanctioned wide number Swansu in 73 for construction of a G plus mezzanine plus 5-story office building, but construction had been made up to G plus mezzanine plus 4-story. The building plan as sanctioned stood lapsed by a flux of time long before. It is needless to mention that the said building plan was sanctioned at a time when the Calcutta Municipal Corporation in 1951 and the building rules under Schedule 16 were in force. Subsequently, the KMC Act 1980 came into force on Swansu and the new building rules are framed. There is no scope under the law to make the construction of a G plus mezzanine plus 4-story building, but the person responsible was found to have been continuing with the construction work for an additional floor over the roof, and ultimately the structure was covered by corrugated tin set. The total constructed areas covering the entire roof was approximately 2310 square feet. The structure as raised come within the purview of definition of building as well as erection of building under section 390 of the KMC Act. Moreover, the covered space of the building has been increased. The construction as made without permission is huge and voluminous. The height of the building as raised is not permissible under the present act and building law. Kindly pause here for a moment. Our cases, it is under the old act as per the plan.
Always remember one thing.
My lord.
Always remember one thing.
My lord.
That there's a life of a plan.
My lord.
The plan is not for eternity.
Absolutely.
So if you fail to construct, the plan goes. Yes.
Lord, I have constructed. Where is the document that I am doing it now? Where is the evidence by the
corporation? You are
corporation?
also not showing anything. Where is the document to show that you have constructed the 5th floor at the same time?
Lord, may I ask
pictures?
Lord,
do you have pictures of your property?
Yes, I can show the picture.
Not of today, sir.
That I need to bring, my lord. Otherwise, I will bring that. I'll bring that. If that is the question, I'll bring that picture. Lord, kindly appreciates, my lord. In Calcutta, it's in Exide more, not in the central Calcutta. It's a very valuable property. May I
That is
ask
why
this
you are
question
adding
to
a floor.
myself?
It is a valuable property.
Lord,
You
why
want
would
that floor.
somebody not do it for the last 50 years,
Maybe
despite having a plane?
Maybe the contractor didn't have the
Lord,
money.
that
How do
is-
you know?
My lord,
How do you know?
Lord, the record says that.
So
The
you
plan
have
is
not
there.
placed anything on record to show that you have constructed the 5th floor at that time.
Just
Why should I disbelieve the corporation? What is the personal interest of an engineer? It's a statutory body. What is their personal interest?
Lord, I cannot
What is their personal
I
interest?
cannot say all this in Lord open court. What is the interest, Lord?
Sir, we go by the department. Yes.
Lord, there's a presumption under 114, but not I can rebut that by showing the documents
Show
that
the
we have
documents.
responded. That was not considered. Lord, two things my lord will kindly consider with your lordship's kindness, Lord. One is whether this is a case under 400 subsection 8 or not, whether there was any emergency situation or not, because the impugned order says there was a proceeding drawn up under section 400. If there was a proceeding drawn up under section 400, that presupposes that they should have given us a hearing. Without hearing, without inspection, without any proceeding, you come and demolish.
There are two proceedings which I have taken.
My lord,
as far as this property is concerned.
lord.
One under 408, one under 401.
Before 400, there was one 400 proceeding that they have mentioned in the impugned order. One paragraph, if I may so kindly come to the impugned order. লিখেছে তো ওখানে. They have written it.
Yes.
Not kindly see the second and third paragraph.
Yes.
Accordingly, the concerned borough
Yes.
issued stop work notice under 401 on so and so date and police. Then the third paragraph.
Yes.
Department also placed the matter to take action under section 400. Now 400 has 400 subsection 1 and 400 subsection 8. Then along with this sketch map and infringement statement, these are made when you have drawn up a proceeding under section 400 subsection 1.
Right.
So where is the urgency that you come? The MIC will pick up one file amongst lakhs of building in Calcutta. Lord, your lordship wanted to know what is their interest.
Yes.
My lord will be flooded with matters where my lord the corporation picks and choose buildings where they will go and demolish. We all know what is the interest, my lord. Now they say that there was a proceeding drawn up under 400, this sketch map prepared, infringement memo statement was prepared. That could only be done if you take up an issue under 400 subsection 1.
That's right. So they have taken up the issue under.
No, they then diverted. If you have issue, not kindly take 400 subsection 1.
I've seen that, sir.
Then they have to give me a notice and hearing.
For this
But as
property,
400
they have
subsection
also
one, they done
initiated
it,
401 also.
Hello? I'm sorry.
They have initiated 400 subsection 1 proceedings
No, that
also.
for a different portion, not for this.
That's what I'm saying.
Yes.
That's what I'm saying, that they have
That for-
initiated that provision.
Not two things. One is the building, and there is a structure behind the building.
Yes.
The 400 subsection 1 proceeding, which they have mentioned in their report, not in the impugned order,
Yes.
is for the back of the building.
Yes.
Now the impugned order talks about only the top floor. Impugned
Yes.
order doesn't talk about anything. But at the cost of repetition, Lord, I'm just not taking a chance, Lord, to place it again. Lord, kindly not admonish me. Kindly take, Lord, read it, para 1 and para 3 together. This is a case of unauthorized construction as reported by the concerned borough. It is understood that the person responsible constructed one additional floor, erection of tin shed structure over existing 6-story building. Now this appears to be now wrong, and as per the report. It was written 6-story, now it is saying about the 4th story I'm doing. Then accordingly 400 subsection was issued. We have never received any notice. Then 3, department placed the matter for 400 on the KMC Act. That means department placed the matter of the tin shed structure before the under 400. Demolition sketch map was prepared. Infringement statement was prepared. The alleged construction infringes several building rules, including rule under so and so. Then the DG building has ordered to take action under 400 subsection 8. So if you prepare a demolition sketch map, if you prepare an infringement statement under 400 subsection 1, you are under a legal obligation to give me a notice. I would have responded. There would have been an inspection. There would have been a hearing. Natural justice would have been complied with, and you would have passed the same order. What they have done, they started the procedure. DG building suddenly decided to alter the route. He said, issue 400 subsection 8. Lord, may I ask one question to myself? What is the emergency?
The emergency is read the order.
Yes, then it goes thereafter. Moreover, the said unauthorized construction, if allowed to stand, may collapse at any moment of time, leading to accident resulting in loss of human life and properties, and may also create several hazards like fire hazard, environmental hazard, etc. Considering the gravity of the situation and safety of public in general, department recommends demolition of the unauthorized structure, construction forthwith under 400 subsection 8. Same department which prepared a demolition sketch map, infringing statement, proceeded to issue notice, stopped as per the order of the DG building, and suddenly reroute and initiated immediate order of demolition. But 408 contemplates a situation where it is emergency. If you have already gone through under 400, you cannot divert and go to 408. Now that is not, kindly allow me to rely on your lordship's own judgment. Kindly have a look at this.
Para 26.
Para 26. Kindly have a look at it. My lord, what I'm seeking from your lordship, I cannot divert. If I have done something wrong, they will demolish. Let them give me a notice. Convert it into a 400 subsection 8 proceeding. I will go and participate. Why you would violate the natural law? Why you would take it in your own hand? Why would the DP building divert from the settled procedure? Kindly look at your lordship's own order, para 26. My lord has
In that.
My lord, I'm reading it for my satisfaction. My lord. It is clarified that the court doesn't seek to curtail the authority of the mayor and council under 408. The court merely underscores that such emergent power must be exercised only upon a proper and recorded satisfaction, both subjective and objective, regarding the existence of an immediate threat of safety. Now, this observation of your lordships doesn't appear in the impugned order, especially if we read paragraph 3. If paragraph 3 was not there, I wouldn't have a case. I wouldn't have a case. They said 400 proceedings drawn up. Now your lordships have not passed order in several matters. Your lordship has kept all the matters, Lord. And in this matter also, Justice Chondo passed the interim order. Then it was extended. Sir, last request, now. So this is my one limb of submission. There is no urgency. Once you have taken that path, you cannot divert. Second, my specific case from day one was that I have not constructed any new building. That finding is not appearing from their report also. That there was an inspection conducted in our presence. Kindly take the report note that they have submitted. It doesn't appear that they made an inspection, that they came in our presence.
Yes, read wherever you want to read.
Yes, kindly, my lord, the first, second page, my lord has seen. Then, my lord, kindly see the third page is the order impugned, which is before your lordship in the writ petition. That is the third page of the report. Then kindly take, my lord, from fourth, fifth, that is the agenda page. Then attendance register. Then, my lord, kindly take, my lord, the inspection book, IB book. Then there is no document subject to correction by Mr. Ghosh that, my lord, ever any inspection was made to find out whether it is emergency, whether it will fall down tomorrow or not. Where from they got it? May I ask this question to myself?
Yes.
There is nothing in the report, Lord. I try and when Mr. Ghosh will correct me if I'm wrong, that there was an inspection, there is an inspection report here. Now kindly take paragraph page 16 of the report.
Yes, read it.
No, kindly take page 16 once.
Just a minute. Yes.
Of the report.
Page 16.
My lord is looking into the petition. Lord, this is a notice that they have annexed with their report. I suppose this is a notice under 401 for stop work. Kindly see whom it was issued. We are the owner of the building. Kindly see whom it was issued. Sandeep Agarwal, Saeed, Power Vision, Nippon, Sanjay Golcha, Manju, Vishwanath Roy, not to us, not to the owners. They have not issued the notice to us. 401 notice. Kindly see, Mr. Ghosh will correct me if I am wrong. We are পুরোটা বল ভেঙ্কটেশ ভেঙ্কটেশ কনস্ট্রাকশন দলিলটা দেখা দলিলটা
First and extra.
দলিল কোন সালের রে?
Start from
Now we have annexed the deed.
page 29 onwards.
Malal will get that deed. No, this is at page 37, the typed copy. This is of 19.
September 1930, 1981.
September 1981 deed.
23rd September 1981.
Which page? What are you showing?
Lord, page 16 of the report.
Yes.
There is a 401 notice.
Yes.
Issued to someone else, not to us.
All right.
Kindly take note, say page 16.
Yes, yes.
38.
The kindly says whom it was issued. Sandeep Agarwal, Saeed, the Power Vision, Sanjay Gulcha, Manju Gulcha Films Limited, Kumar Vishwanath Roy, Ticket Trading. We are Venkatesh Blood Construction. We are the owner of the building.
23rd September.
You must have sold it.
My lord,
You must have sold it to these people.
lord, they have issued the demolition order to us, but the notice to someone else.
They are the occupants.
But they have issued the demolition order to us and notice to someone else.
September 1981.
23rd September 1981 we
Are you
purchased.
still the owner of all these floors?
They are our occupants in the floor, but we
you
are the owner of the building.
Are you, what do you mean owner of the building? Are you the owner of these floors? You're not the owner, sir. You must be the builder. Venkatesh Construction must have been the builder who has sold these floors to different owners who are occupying it today.
I think we leased it out. I am not sure, but it is a leasehold. We have leased out several floors to several occupants. But the deed is there. The deed is there. Kindly come to the deed.
38 onwards.
Page 38 onwards. The deed is there. The deed of conveyance is there.
Sri Venkatesh Construction. Page 38.
Kindly come to page 38. The previous owner sold it to us, Sri Venkatesh Construction Private Limited.
Yes. So you also must have sold it, na, sir? You are holding it. Are you the owner?
Not my, according
Are you
to
still the owner?
not, I need to take instructions on that. By my instruction is there are occupants who have been leased out perhaps, whether there is a sale
Where is
deed
the
or lease
lease
deed.
deed, sir?
We'll produce it before your lordship. My lord, if my lord wants, my lord will produce all the lease deeds.
No,
Whoever is leased out.
when you are alleging that the notice has not been served,
Not to me. That
sir,
is
that's
appearing.
what I'm saying. Then show me the ownership.
But that's the deed.
Page 49.
So the deed is after the deed. You must have sold this property.
Lord, that we should have mentioned if that was done. Lord, I'll come back with instructions if whether it is sold or not.
Which construction company holds the property?
Lord,
You are a developer. The owner would have been X person. You would have got the
Why not?
development agreement executed, and that is how you are the
Purchased
owner.
the
Which
property.
yes, you purchased the property. You constructed the property,
Yes.
and in all probability, you sold the property.
Not perhaps leased out. Perhaps leased out. I'll check not and tell you.
Maybe
lordship.
few of. I have never seen a builder leasing out properties, but maybe you are a very different kind of a builder. You must have leased it out.
Lord, they have issued notice admitted to others, not to me.
Sir, that's what I'm saying. When you are making this contention, then you have to support it by the fact that you are still the owner of the property. They have given it to people who are occupying it. They are the ones who are there. So they have given notices to those people who are there in the flat. But you are not there in the flat.
But in the report, they are saying that we have constructed. But I bow down to that, Lord. I'll produce the lease deed before your lordship, Lord. I bow down to that. But Lord, today, what I'm trying to, Lord, submit before your lordship is not two things. Lord, kindly appreciate two things, Lord. That there is no urgency to pass 408 order.
Yes.
May I just take leave? The only thing what he is arguing, it is beyond the previous.
Yes.
Lord, there's no urgency for 400 subsection 8. First. Second, they initiated 400 proceeding. They diverted to 400 subsection 8. Third, the construction was already there. It was just a case of repair. Fourth, it is not a construction or a case where, my lord, there is no plan. They are saying plan was there, plan got expired. Now we are making. So this kindly adjudicate this, my lord. There is no affidavit filed before your lordships. The interim order,
Affidavit not filed.
only a report is filed. We have taken an exception. Lord, there was an interim order that your lordship passed that has been extended. Lord, let us come back with these documents to satisfy your lordship's conscience.
I am satisfied.
Now, my lord, Today,
I'm satisfied.
yes, Lord, I have taken instruction. First, second, third sold out. Fourth, fifth, sixth, we are the owners.
Has to be
Fourth,
so.
fifth, sixth, we are the owners.
All right.
That's there. Now, kindly take me this document at page 10 once, page 10 of the report. The inspection book
Page 10 of the report.
is the inspection book what Mr. Ghosh was referring.
Yes. Yes. Yes.
And from here, I cannot figure out how much premises or what is the structure that they have mentioned in their report. But today, kindly appreciate one thing, the entire floor will go, which has been there for last 50 years. There is no evidence forthcoming before my lord that there was ever any inspection made. Even their report doesn't say so.
The report says so.
No, they must have annexed the inspection report.
The
But-
report says.
But I don't find any inspection report in the inspection memo in the report.
They have, in
My
the
lord,
report which they have filed, they have.
but they must have, they should produce that. Lord, the government, the state,
Unauthorized construction, nothing to be produced.
Lord, the state should produce the inspection report. Lord, kindly considers this.
Yes.
No, only what I want is that it should be relegated to 400 subsection 1. They are taking up another proceeding. So we'll go and fight that out. But Lord, today, without a hearing, without any opportunity of hearing, without any Lord, kind of opportunity given to me, they will come and demolish my property. Just on the saying that our
What is that 401 notice for other portion? What is that, Mr. Ghosh? That 401 notice is for other portions.
Yes, in the second page of the report. The notice is not annexed.
The notice is on annexed, it's a different thing.
Kindly take note the last paragraph of the report. In view of the said decision, page 2, in view of the said decision, resolution MIC 13 December 2024, such an action for demolition of the unauthorized structure were undertaken. But since the Honorable Court by its order dated 16 January 2025 directed the corporation not to make any further demolition of the structure of the said premises, KMC stopped the progress of the demolition work. 7 except above structure under order of demolition of MIC dated 13 December 2024, the petitioner has also made certain other unauthorized construction work in other areas of the building for which a demolition proceeding under 400 subsection 1 was initiated to the intimation and information of the person responsible. The demolition proceeding under the said section has already been conducted and completed by passing an order which is pending for approval by the MIC. Now we asked for a copy of this. They did not provide. We filed the second writ petition to get a copy so that we can challenge it with the tribunal. Now, my lord, we got the copy. We are taking steps for doing that. Even then also, they did not give us a hearing. Now, if your lordship sees here in the impugned order, there was also a proceeding under 400. Mr. Ghosh is not, the corporation is not answering what happened to that proceeding. Suddenly, how could the DG building, Lord, kindly have a look at 400 subsection 1.
I made it clear, my lord, there are two proceedings, one for 400 subsection 1, that is the sanction part, the unauthorized construction, sanction area, and another is, my lord, which is considered to be without sanction because of lapsing of the plan. He is, my lord, jumbled the two issues, my lord, before the lordship. So far as the 400 subsection 1 is concerned, he has the courses open to approach before the appropriate forum after obtaining the copy. Now that is, my lord, in our report, that is pending, my lord, approval by the Mayoral Council.
No, order is
so far as
passed.
that is, my lord, 400 subsection 1. But for 400 subsection 8, order has been passed. Well, they are, my lord, they are raising an issue that it should be demolished.
Yes.
This is the order. I have got
Only
that.
thinking, my lord, repeatedly they are saying that give me a hearing and all these things.
You will
That they
not
are,
give me a hearing.
this is only purpose is to prolonging the unauthorized construction to continue. This is the whole object. That everybody is now trying that the one provision should be rendered inoperative and one provision should be operative. Although, my lord, that particular section has been declared to be inter-virus by this Honorable Court on a challenge to the validity of that particular provision. Now, so far as the 400 subsection 8 is concerned, my lord, that there is no provision for appeal. I admit.
Exactly.
But when there is a provision for appeal, they have come to this court, my lord, for judicial conscience of the construction. Whether, my lord, this should be allowed or not, they are getting a hearing before the
Lord, a
court.
tin set construction has
Hearing
become
would
so
be allowed or
emergency.
not?
A tin set construction has become so emergency.
Take
It will, Lord, only one paragraph I show from your lordship's judgment, my lord. Kindly take that judgment that I have given to your lordship's paragraph 22. Kindly sees, Lord. Kindly see para 22 of your lordship's own order, my lord.
Yes.
Considering that further delay caused by calling for affidavit and proceedings would defeat the very object of invoking the emergent provision, this court deems it appropriate to remand the matter to the Kolkata Municipal Corporation for re-verification of the relevant document, facts and figures. Upon such re-verification, KMC shall arrive at a fresh decision as to whether the invocation of 408 is warranted. Only if KMC arrives at a conclusion based on subjective and objective assessment, Lord, kindly consider, Lord, whether this subjective and objective assessment is there in the impugned order or not. It's not there. With greatest of respect to Mr. Ghosh. Your lordship's order continues. I am reading. My lord need not look into it. My lord has passed the order. Only if KMC arrives at the conclusion based on the subjective and objective assessment that there exists a grave urgency and immediate demolition is imperative for safeguarding the public safety, may the authority proceed with such demolition. In absence of any imminent threat to life or property, the petitioner shall be afforded an opportunity of hearing prior to any coercive action in respect to the alleged unauthorized construction. Lord, suppose, let me, Lord, I don't know what your lordship will do. Suppose if my lord passes this order, they need not give me a hearing. They will make a subjective assessment. I will go back. They will inspect the property. And your lordship has kept all matters of 408 on 25th of June as Mr. Chakraborty was telling me. Lord, kindly assess, Lord, whether this is a case. A tin set construction will fall down immediately, which is so dangerous that despite issuance of 400, they will have to detour and go to 400 subsection 8. My lord, kindly have the charity to consider this. Kindly extend the interim order. Let us come back.
Decided. Take down. The petitioner has preferred the present writ petition seeking
may I take a lordship?
Yes. Quashing of proceeding under section 408 in respect of illegal and unauthorized construction being carried out at premises number 240B ACJ Bose Road, Borough 8, PS Bhavanipur, Calcutta. Full stop. It is a contention of the petitioner that the tin shed erected on the roof of the 6th floor of the building is not illegal and unauthorized. Full stop. Petitioner contends that the impugned order passed under section 408 is per se illegal, since the department had taken recourse to section 400 and a D sketch and infringement statement were being prepared. Full stop. Petitioner states that the DG building's order had ordered that action should be taken under 408, though they had initially invoked section 400 of the KMC Act. Petitioner contends that due to the invocation of the emergency provision under section 408 of the KMC Act, the petitioner is devoid of any hearing. Full stop. He further states that the report of the corporation itself does not show the reason for invoking the emergency provision under section 408 of the KMC Act. Full stop. He further relies on the fact that the notice which was issued was not in his name. Full stop. notice which was issued under 401 was not in his name. Full stop. Any other contention?
But I ought to have relied on the judgments, well, my lord. Your lordship.
Forget you should have got the judgment.
Yes,
I'm not
that's
going to
my
give you. Learned counsel for the petitioner further submits that the corporation should have taken a subjective and objective decision before invoking section 408 of the KMC Act. Full stop. Learned counsel for the respondent, Calcutta Municipal Corporation, Mr. Ajay Ghosh, submits that the petitioner has carried out submits that there was a sanctioned building plan issued in 1973, issued on 26/6/1973 for construction of a G plus mezzanine plus 5-storied building. Full stop. But the construction had been made up to G plus mezzanine plus 4-storied. Full stop. The building plan as sanctioned stood lapsed by a flux of time. Full stop. He further states that the building plan was sanctioned at the time when the Calcutta Municipal Act 1951 and building rules under Schedule 16 were in force. Full stop. Subsequently, the KMC Act 1980 came into force with effect from 4/1/1984, and the new building rules were framed. Full stop. He states that there is no scope under the law to make construction over existing G plus mezzanine plus 4-storied building, and that the additional floor over the roof is being constructed illegally with corrugated tin sheds. He further states that the area of unauthorized construction is approximately 2,310 square feet. Full stop. Mr. Ghosh supports the order passed under section 408 of the KMC Act, since he states that such unauthorized construction if allowed may collapse at any moment of time, leading to accident resulting in loss of human lives and property, and shall also create several hazards like fire hazards and environmental hazard. Considering the gravity of the situation and safety of public in general, the corporation had decided to demolish the structure under section 408 of the KMC Act. Mr. Ghosh further states that there was a notice which was issued under section 401 for work stop. Work stop notice was issued under section 401, though that did not deter the petitioner to carry on with the construction, and the entire construction was carried out despite a work stop notice being issued. Full stop. The report further indicates that there was a brick wall up to 3 feet, approximately a brick wall of 3 feet was constructed approximately on all sides of the existing roof, and over the brick wall, the petitioner had fitted or fixed steel frames structure on the up on the roof, and had fixed the glass in the panels over the structure to construct a entire floor illegally and unauthorizedly. Full stop. Mr. Ghosh further submits that in terms of the sanctioned building plan also, there has been deviation and unauthorized construction which has been carried out by the petitioner. The department has issued notice under section 401 of the KMC Act in terms of those illegal and unauthorized construction being carried out in violation of the sanctioned building plan. Full stop. Though Mr. Ghosh makes it very clear that the present construction, which is in the form of a rooftop shed along with steel frames and glass windows, is completely illegal and unauthorized, and since it can collapse and cause safety concerns to the inhabitants of the building, the corporation has invoked its emergency provision. Full stop. This court is conscious of the fact that the Honorable Supreme Court in such and such judgment has deprecated any sort of illegal and unauthorized construction. The Honorable Supreme Court has observed that there should be zero tolerance as far as unauthorized construction is concerned, and that the authorities should sternly deal with any sort of unauthorized construction. In the present case, since the petitioner has carried out the construction of the entire floor over the rooftop, which is indicated as the 6th floor, in itself is harmful for the structural stability of the building as well as for the other occupants of the building. Such unauthorized construction should be sternly dealt with, and the corporation has rightly invoked the emergency provision since it is a matter of concern and safety for the general public, wherein such unauthorized construction, despite work stop notice, is allowed to be carried out. It should be sternly dealt with the corporation. This court finds no infirmity in the impugned order and directs that the unauthorized construction which has been carried out in violation of the sanctioned building plan shall be immediately demolished in accordance with law. Full stop. As far as the notice under section 401 of the KMC Act is concerned vis-a-vis the unauthorized construction in violation of the sanction plan, the petitioner states that he has already filed a writ petition number
9884 of 2025.
9884
of 2025.
2025. Full stop. This court does not wish to say anything as far as has already taken his recourse to the said proceeding by filing a separate writ petition. Full stop. In view of such observation, the present writ petition is disposed of.
But it may make one submission.
Challenge it.
No, that's it. But only one thing, your lordship has been pleased enough to direct the entire unauthorized portion. Kindly restricts them only in respect of the 408 order.
The rooftop.
I made it clear.
My lord has stated all the unauthorized
construction as far as the rooftop is concerned.
No, my lord has with deepest of only that much.
That will be done. Only till the rooftop. 408. Any unauthorized construction in terms of section 400.
With folded hands, may I make one loquacious prayer?
Yes.
Lordship, be pleased enough to grant me 2 days stay, so that I was enjoying. And
do you think they will demolish in 2 days?
My lord, I think, because Mr.
I don't think so.
When
2 days,
Mr. He has nothing and will done.
Unauthorized construction,
2 days
now in
with
terms
folded
of
hands,
Supreme Court,
before the
nothing.
vacation, 2 days.
Sorry, sir. Mention it today. You are expert.
Mr.
Stay.
Bhattacharya is there.
That's why I've indicated.
Only 1 day they can obtain.
That's why I'm saying, Mr. Bhattacharya, they'll have a better luck. Next.
Grateful minute. Phone को
मैं दे रहा हूँ ये जस्टिस महादेवन का जजमेंट है 2025 का sitting with Justice Pardiwala. I'll give you the citation. Mahadevan sir, निकल जाएगा.
I am for the full conditional proposition.
But 5 is my application.
To file a report, but I could not file it after vacation. After vacation.
After vacation.
1 week after vacation.
Item 5.
Item 5, yes.
This is already there's a stay for 4 months, right?
No, 2 months. Lordship kindly takes up the order that 10th March. 10th March, interim order granted earlier shall continue for a period of 2 months from date. So that was till May 10th. Thereafter, I mentioned the Lordship before 15th and matter is appearing today. So let them file a report. Lordship kindly extends the time and my Lord will kindly keep up the matter. Any day subject to my Lord's kindly, I am here before Lordship my Lord, to argue the matter.
Learned counsel for the respondent corporation seeks further how much time?
1 week after vacation.
Further 2 weeks, 3 weeks time to file his report. Full stop. The interim order granted earlier shall continue further for a period of 6 weeks. Or until further order, whichever is.
Grateful.
ये बुलाओ break. I'll just come back in 5 minutes. Yes.
My lord, this matter, my lord, I am protected by an order of my lord stay, but in the meantime, your lordship, my lord, has called for a report. I have already, my lord, used an exception to the report. My lord, kindly remembers here, my lord, the one of the matter was being moved before the appeal bench, my lord, the public interest litigation, seeking that yes, I have encroached upon public road. So this honorable court was not, my lord, happy to entertain the public interest litigation, but since the public element of encroachment of road was being, my lord, mentioned, so directed the corporation to look into the matter whether there is an encroachment of the public road. While doing that, my lord, they have undergone an exercise on utter surprise to my client that they have recalled their own, my lord, order of revised sanction, which is, my lord, your lordship directed, my lord, them to file a report. They have given a report, my lord. I have used an exception of filage. My lord, on the last occasion, my learned junior, my lord, has filed the exception. My lord, today is for, my lord, I am seeking, my lord, before your lordship, my lord, the exercise of jurisdiction by the Howrah Municipal Corporation in an, my lord, matter wherein the public element was directed to be looked into, but they by their own have recalled their own revised sanction. Whether that can be permissible under the law.
Show me the orders.
Yes, not if you.
Fact is, these were G
La-
plus 2 structure. Thereafter, 3 floors have been constructed.
Not constructed. They have not revised it. But I shall show before
Retained
the
maybe. I
Kindly
don't know,
takes up.
but so far as the, my lord, fees, they have said retention fees, 4,76,000 and 99,000 have been paid by them in 2 separate occasions, but we have to verify that. But regarding 3 floors, that fees, I have to find out whether that.
If your lordship takes up, my lord, page 24 of my lord's brief, may I just indicate how, my lord, yes, my lord, how this, my lord, has the my lord, may I just place before your lordship? The petitioner alleges that there is an encroachment of public land. Learned counsel appearing for the private respondent submitted that the personal dispute is sought to be camouflaged as a public interest litigation, be that as it may, if there is any encroachment in public road, the same should be prevented and the land should be restored as a public land. Lord, this was the direction. Thereafter, the Lord, therefore, without going to the merits of the matter, there will be a direction upon the third respondent, assistant engineer building, Howrah Municipal Corporation, to conduct an inspection and after notice to all the concerned and proceed to take an action in accordance with law as expeditiously as possible. If your lordship turns over the page, my lord, to, my lord, page, এটা কত নম্বর page? 28. এটা? My lord, page 28. Now your lordship will get, my lord, the order impugned before your lordship. My lord, the second paragraph is being mentioned wherein, my lord, my retention fees.
Yes.
My lord, I will join an issue, my lord, with regard to, my lord, the last paragraph of page 28, my lord, wherein, my lord, it has been mentioned that as if I am amalgamated. My lord, I am really under utter surprise because they have carried out an inspection only with regard to restricting the division bench order, that whether I have encroached upon the public road. While, my lord, giving the order Milord, they have stated, I have done this, I have done that. Milord, that apropos, Milord, I have to, Milord, given a notice that, look, you are being asked for to show cause as to why these things have been done. Milord, the division bench stated that I have encroached the public road or not, that has to be looked into. While doing so, they have carried out an inspection and thereafter they found I have amalgamated. Milord, there is no, Milord, iota, Milord, there is no amalgamation. Milord, on the contrary, if your lordship turns over to page 30, my lord, kindly see, Milord, this is a decision which was being held by the corporation. Milord, page 30, if your lordship, Milord, has your lordship?
Yes.
Milord, it's a memorandum dated 27th of October 2014. Has your lordship got it, Milord?
Yes.
There is a meeting, Milord, that has been held on 15th of October 2014. And according to that, Milord, initially I was being directed to deposit, Milord, this amount for revised sanction. Milord, I have done that, Milord. The next page, page 31. If your lordship again turns over the page to page 32, Milord, this is another meeting they have held on 9th of March 2015, and they have imposed this for revised sanction. So twice this has been done. My building is standing as on today as per the decision of the, Milord, corporation. So this honorable court has never directed, Milord. I shall apprise your lordship, the Howrah Municipal Court, your lordship knows, Milord, better than me, that even the judicial authority or quasi-judicial authority, they formed under the statute, they have to act according to the four corners of the statute. And the review, power of review is a, Milord, one of the creature of the statute. If the review power is not granted expressly by the provision of law, they cannot exercise it. It's not that the superior authority is calling, Milord, your lordship knows, as SOB, Milord, Special Officer Building, Milord, can pass a regularization order, Milord, under the KMC Act. Milord, it is, Milord, the building tribunal who can take the call, yes, whether that power of regularization has been exercised correctly or not. Today, Milord, no one has thrown challenge to this regularization. Twice this has been done by the corporation. The act does not prescribe, Milord, any power of recalling or review to be exercised by the authority. How, Milord, the authority, with utter surprise, in a proceeding wherein this honorable court directed an exercise to be done with regard to the public, Milord, encroachment, have done the entire thing. Milord, I will rather, Milord, persuade your lordship, Milord, to cite, Milord, some of the judgment wherein, Milord, this honorable court and, Milord, the honorable Supreme Court also specifically stated that the quasi-judicial authority by their own, if not being prescribed by the statute, cannot exercise the power of review and recall their own order. Here, Milord, it is a comprehensive committee of the, Milord, corporation who have taken the call, revised the sanction, imposed penalty, paid by me. How in a proceeding, Milord, wherein this action has never been challenged by anyone, the corporation can suo moto do this? Milord, this is something which called a stop.
Suo moto, the corporation cannot take action against unauthorized construction.
No, Milord, I am not on that. I am saying, Milord, today a building is standing. What the corporation's grievance today, they are saying that additional floor is being constructed. It is the corporation who has, Milord, upon two occasions, taking a decision, has revised the sanction, taken fees from me.
There is no revised sanction.
Milord,
it is only a retention.
Retention. Milord,
there is no revised sanction.
Milord, retention is something.
Lord, go through page
Seeing the,
57.
Milord,
just a minute.
Milord, seeing the, Milord, the structural stability and the FIR of the building, if the corporation is of the opinion that this can be retained under the law, they impose the penalty and, Milord, retain it. Milord, that has been done. And, Milord, I am not saying, Milord, the corporation cannot suo moto exercise its power so far as regards, Milord, the unauthorized construction is concerned. I bow down before your lordship. That is the power suo moto given by the statute. They are the, Milord, authority to look into all the affairs. Yeah. But they have once looked into it. They have exercised their power. They have retained it, taken fees from me. Thereafter, this honorable court have directed them to do a restrictive thing. While doing so, they have recalling their own order. There, Milord, I am joining an issue. If the power of the corporation is not given by the statute to recall its own order, how this same authority can recall it? Milord, that is, Milord, my principal grievance. And if your lordship so, Milord, desire, Milord, I have shown before your lordship what was the previous direction. If the corporation is of the bounded view that they now wants to take a decision apart from the public law element, Milord, they can give me a notice of fresh hearing. The inspection can be done in that fashion, whether the amalgamation is done or not. The entire thing can be revisited. I will not be under surprise if Mr. Banerjee can say that yes, this thing has been done under a guise that whether I have shown them what? I have even not shown them anything apart from the public law element factor. I have allowed them, look, I have not encroached upon any public road, you can measure it. They have taken the call, and in the entire order, as your lordship seen, there is no iota of anything that I have done which is has been alleged in the petition, public interest litigation.
Yes.
Because what I am today arguing before your lordship, I am losing a forum because they are not invited me to make that argument before the authority that you are recalling your own order. So this is the argument that they cannot exercise their power of review. I am making for the first time before your lordship because I have lose a forum. They have not indicated me that they are going to recall their own decision. Had it been a case that I would have submitted the same, which I am going to argue before your lordship, so I will lose one forum. So if Mr. Banerjee can say they are taking a call that whether they can recall their own order or not, let them take a decision. I will argue that before the authority. And if they are of the opinion, I can come back before your lordship. Because today, what is not being done, I am losing a forum. I have argued comprising myself with regard to the allegation that has been made in the public interest litigation, which is restricted to public law anyway.
Yes.
That comes to page 27 once. Next at P4. Where is a G+2 sanctioned building. 27. It is a G+2 sanctioned building where there are deviation in G+2 also. Where sanctioned area ground floor more or less 78.43, deviated area 48.02. Full unauthorized portion is 143.95 square meter. That means 1,430 square feet. Sanction area first floor.
Just a minute.
Sanction area first floor is 78.43 square meter.
Yes.
Deviated portion 48.02 square meter. Unauthorized portion means 143.95 square meter, means 1,430 square feet.
Yes.
Now our sanction area second floor is 78.03, unauthorized 48.03, a deviated portion 48.03, full unauthorized second floor more or less 143.95 square meter, that is 1,430 square feet. And thereafter, third, fourth, and fifth floor are more or less 270, 270, 270. That means 270 means 2,700 square foot in each of the third, fourth, and fifth floor. So, 7 is total deviated area up to second floor. Deviated area, but 144.06 square meter. Total full unauthorized area is 1,243.405 square meter, means minus 12,430 square meter.
Yes.
A square foot. But total unauthorized area, again it is said 1,387.11 square meter, 13,870 square foot. So total sanction area comes to 235.29 square meter, total constructed area so and so 1622.04 square meter. Total retained area now comes.
Yes.
Total retained area is G+2 level at holding number retained after giving money. Retention fees 99,504, more or less 144.06 square meter. Total retained area up to G+2 level at holding number so and so. Submitted retention fees to the tune of 4,76,671. More or less 431.85 square meter. Now comes to the unauthorized area. So unauthorized area there remains, and for that reason we are going for it. We have given this inspection report. We have filed the self demolition order in terms of that.
So you are saying that the retention fees is for the areas first floor and second floor. The amount of payment.
G1 and 2.
The payment which has been made is for the first floor and second floor.
That I have got instruction. Now I can, if your lordship so directs me, I can file an opposition to that effect. If your lordship so directs, I can.
Because they are the meeting dated.
The
meeting.
I can file an opposition to that effect and to find out what type of area was found to be fully unauthorized. So my engineer, what I get it from the inspection report is that third, fourth, and fifth floor is completely unauthorized. So retention fees has not been taken against that. that I can find from here. If your lordship directs me, I can come with a full and fledged opposition. If your lordship so directs, thereafter I will file the opposition. If your lordship is satisfied that retention fees is for G+2, what I can find from the inspection report, then
So
my
that
lord,
you have to clarify, Mr.
I have clarified, my lord, G+1+2. That is
G+1+.
that is deviation area. We have taken the fees.
Right.
So retention fees have been clarified is G+1+2 deviation only, and that is 4 lakh something and 1,93,000 something, and not that of third, fourth, and fifth floor. That I can find from here.
Yes.
Yes, my lord. Now, my lord, if your lordship takes, my lord, page 30 and 32 side by side, what Mr. Banerjee is saying that his retention is restricted to G+2. Kindly see, there are 2 meetings, my lord, has been mentioned. There are recording of minutes in the corporation. Let them show that if this 2 meeting is restricted to G+2, I don't have any case, my lord. I will have to, my lord, bow down that. But my lord, my specific instruction initially that 99,000 and odd amount which they have given, that is restricted to that, my lord, G+2. But additional floor, they have taken, my lord, the bigger amount, which is 4,76,000, and they have allowed that by virtue of meeting of 9th of March 2015.
And one thing is to be
And my lord, kindly
whether
see,
extra 3 floors, they have given any
Retention fees.
My lord, that 3 floors is extra above G+2.
That's right.
So structural stability report was not been submitted. I don't.
That is not required. Mr. Banerjee, what are you saying?
My lord, my lord.
If you have to help them, don't help them like this.
My lord. That is not required.
And they have given, my lord, the completion certificate, my lord, by virtue of 32, page 32. My case was that, my lord, I am really losing a forum. Because this ought to have been done at the time of hearing before the corporation.
Losing nothing. You're going to lose all the floors. Take down. The petitioner has challenged the impugned order dated 25/4/2024, wherein the respondent has directed demolition of unauthorized construction on at the 2nd, 3rd, and 4th and 5th floor. The 2nd floor is with the plan.
Yes, yes. G+2.
G+2 is within the plan, but deviated portion is massive. That I can find.
Second,
but in any manner that has been retained.
5th floor of situated, क्या लिखा है एक बार? So at property number 239 and 239/2, Belilius Road, Ward number 19, Havra. Learned counsel for it is an admitted fact that the petitioner has a sanction plan for G+2 floor, G+2 building, and he has constructed third, fourth, and fifth floor at holding number 239 plus 239-2 Bellisle Road illegally and unauthorizedly. Full stop. Petitioner states that the respondent corporation has received retention fee of rupees 99,504 and rupees 4,76,670.671 on 27/10 and 27/10/2014 and 25/3/2015 respectively for retention of the unauthorized construction over the said property. Full stop. Learned counsel for the petitioner states that since the petitioner has accepted the retention amount, the unauthorized
But the corporation has
construction-
accepted.
the respondent has accepted the unauthorized amount, the construction stood regularized. Full stop. That is the contention?
Yes.
All right. Learned counsel for the respondent corporation has filed a report dated 24/4/2024, wherein it is stated that unauthorized construction has been carried out on the first floor, second floor, third floor, first floor, second floor, third floor, fourth floor, fifth floor. Full stop. Though there was a sanction plan for G+2 building, despite the same, there were deviations which were carried out by the petitioner beyond the sanction plan. Respondent submits that on the first floor,
Ground floor, first floor, second floor.
on the ground floor, ground floor, first floor ही नहीं, ground floor, first floor, second floor जो पहले लिखा है ना, ground भी add कर देना. The report shows that ये पूरा यहाँ से ले लो, tick to tick. From the bare perusal of the report, it is evident that the retention amount has been paid for G+2 level holding at 239 Belisius Road, and an amount of rupees 99,504 was accepted for the deviation in the property to the extent of 144.06 square meters. In similar fashion, rupees 47,661 was accepted in terms of the deviation carried out on the G+2 level.
Not 47,000, but
4,76,671 on G+2 level at holding number 239/2 Belisius Road in terms of the deviation to the extent of the deviation of 431.85 square meters. Full stop. Learned counsel for the respondent states that the retention amounts have been paid for the unauthorized construction carried out by the petitioner on the sanctioned floors in deviation of the valid building plan. Full stop. Counsel for the respondent states that the entire third, fourth, and fifth floor are without any sanction plan and are illegal and unauthorized construction, and that no retention amount has been accepted by the corporation for the said construction. Full stop. This court, after perusal of the after hearing the arguments of both the parties and perusal of the documents, comes to the finding that the retention amount has been paid only for the construction carried out up to G+2 level.
There is no mentioning in both the
11 and 12.
11, 12, my lord, that is their contention without referring to the minutes of both these two meetings. Kindly call for the minutes of both these two meetings.
From the
Mr.
minutes,
Banerjee, my lord, is saying, my lord,
from the minutes you show me. Mr.
Lord,
Banerjee, are you
they will not
refuting that?
provide me. That kindly see page 30 and 32 once, my lord,
Yes,
for
yes.
my satisfaction.
Yes.
Boro Sabhar, my lord, that is the meeting, my lord, in the
Yes.
middle portion, they have mentioned on 15th of October 2015, they have taken a decision
Yes.
by recording a minutes.
Yes.
And thereafter on 9th of March 2015, they have taken a decision. This
Right.
used to be done by, my lord, the MIC, Mayor in Councils.
Right.
My lord, every my lord, councillors were
So
to be
that is
present.
what he has clarified in the report.
My lord, without, my lord, annexing, my lord, otherwise, this is a decision taken by them. They have taken a decision without providing me to the court for the satisfaction of the court. What was the minutes of that meeting? Merely by saying from the bar,
What do you mean by minutes of the meeting? They are saying it very clearly in their report.
without my lord, ascertaining to what was the
They are
decision
saying-
taken.
They
But
are
this is
saying what
something that the authority once say, my lord, that will be sacrosanct. My lord, I cannot say, I cannot challenge that. My lord,
Sir,
the
have you,
amount,
in your exception, have you challenged this?
my lord, what, my lord, this particular,
Yes.
yes,
the
my lord, I
report?
have entirety, I have not dealt with.
Show me from the exception that you are saying that the amount is,
My lord, this is,
they are charging is for third floor, fourth
but in
floor.
the
fifth
writ
floor.
petition itself, I have stated. Kindly takes up my writ
That is
petition.
not made out from the report. Have you challenged this?
That has been mentioned, my lord, in the whatever annexed, my lord, in the report, that has already been annexed in the writ petition by me.
Take down.
By me in the
The-
writ petition, I have annexed.
I'll deal with this. Learned counsel for the petitioner states that the minutes of the meeting dated 27/10/2014 and 25/3/2015, wherein the retention amount have been charged, does not reflect for which floors the said amount has been accepted by the corporation. Full stop. The said fact is not disputed and is evident from the report filed by the Howrah Municipal Corporation dated 24/4/2024, wherein the report indicates that the said retention amounts have been taken for the illegal and unauthorized construction carried out in deviation of the sanction plan of the building situated at 239 and 239/2 Bellius Road. Full stop. In view of the said fact, there is no illegality in the order dated 25/4/2024, which has been passed after the corporation has been passed in compliance of order passed by the Honorable Chief Justice of this court dated 18/1/2024. And in terms of the said order, a hearing was given to the petitioner on 15/4/2024. Full stop. Since the petitioner has,
It is also my case that petitioner was not being heard. This is respondent number 5 who has been blocked.
I'm just reading it from this order only, sir. You see the order.
But that is not my contention in the writ petition. Those are the grounds of my writ petition.
Sir, you
including
see
that the order, they have.
You can challenge it. What
I
is
have
the
challenged.
That's what I'm saying. You can challenge my order also, sir. I'm just reading it from here. This is not what I am
under
saying.
impression your lordship is asking that minutes of the meeting. Then in that event, may I rely upon two of the judgment where they cannot review its own order, being the quasi-judicial authority. One is 1971, volume 3, SCC, page 844, paragraph 4 of that.
Yes. Yes, read it.
Yes, paragraph 4 is dealing with that the quasi-judicial authority without having the power of the statute to recall or review its own order cannot exercise that. On the same line, my lord, two other decision, my lord. 87, volume 4 SCC page.
Learned counsel for the petitioner has relied on two judgments.
Three, my lord. The latest one is 2019.
On three, on so and so, so and so. The facts of the present case are distinct and are not attracted in the present case. Full stop. The contention that the corporation has no power to review its own decision is not under consideration in the present writ proceeding, since the corporation has passed an order, is not under this present writ proceeding. So full stop. In view of the said fact, the present writ petition is dismissed. ये डालो ये जो पहला वाला मैटर था ना वेंकटेश, इसमें डालो इसका फाइल, ये भी उसी में डालो.
My lord had a specific query, my lord, to be answered by my learned friend. I just will remind you, lordship, this is with regard to, my lord, a gym, my lord, gymnasium, which, my lord, I am running, my lord, at the top floor. My lord, they say that, my lord, there is a bar, my lord, this, my lord, conversion, my lord, change of user is, my lord, not what is, my lord, permissible under law. My lord wanted to see, my lord, the provision of law, which, my lord, debars me, my lord, from running the gym. Because, my lord, otherwise, this conversion has been, my lord, permitted. Order passed, which is appealable, my lord, in the building tribunal. They have, my lord, written a line saying in the writ petition that we shall not go to the appellate court. That's, my lord, there.
The third floor was sold as a residential premises. The deed of conveyance has a specific clause that it should be used as for residence only. I live on the fourth floor of the premises. Now, after purchasing the said premises, they have converted it into a gym. Now, under what circumstances can these be converted? Your Lordship had asked us to come back with this. Your Lordship kindly takes up section 435A of the KMC Act.
You have got the conversion done.
Yes, there is an order passed, which is under challenge in writ petition.
Yeah.
Yes, Your Lordship. Change of use, which we have challenged it by way of a writ petition.
So till the time that conversion is a valid conversion, they can run the gym. You have already challenged it. Then this becomes infructuous.
Yes. I did not follow Your Lordship. Can we?
I am saying that since you have already challenged the conversion to the commercial property.
In this writ petition.
In this, which writ petition?
This writ petition, Your Lordship is hearing.
The pending which is
yes, yes, Your Lordship.
Which is
Your Lordship was
order, going by the statute. That is an appealable order. There is a division bench decision, very recent, passed by my Lord Justice Arijit Banerjee, says that this kind of order cannot be challenged in writ petition.
Your Lordship, this was fallen from Your Lordship, since Your Lordship was hearing a lot of cases where change of use was allowed by paying a fee. So Your Lordship had asked us to come back with the provisions under which they can allow such changes. Lordship kindly takes up section 435A.
Yes.
Allowing trade or business alongside major roads. In residential buildings.
I'm sorry.
Lordship, I am led by Mr. Bhatt.
Yes.
On the previous day, it fell from Your Lordship as to how these things are regulated. Previously, admittedly, it is my duty to point out where the shoe pinches, because where the law is against me, apparently. If my lord takes 435 capital A, the law says in a residential building, non-hazardous things are permissible. Schedule 5A also contemplates a gym. And whatever, it is there in Schedule 5A. Let us take it, it is there. Now, therefore, Your Lordship would have to look at it from, subject to correction from this angle. I was given a sanction for a G, first floor, second floor, third floor, and the terrace. Third floor and second floor are admittedly residential. And my lord, there is a separate, completely separate residential part entrance. The staircase is completely different. The first floor was sanctioned as a commercial or a mercantile part. And my lord, it has been let out to some offices. The ground floor is, my lord, garage space, which, my lord, according to the municipal authorities that weighed with them, my lord, I had a shop room, MediPlus. My lord, there's a medical shop. A portion of the garage has been utilized by me, which weighed with them, saying that section 416 should be applied. My portion should also be regularized. My lord, I undertake to your lordship, my lord, whatever portion that has been used by me insofar as the garage is concerned, my lord, that is neither here nor there, I shall remove it. But I am principally on, my lord, section 424 first. Second is, my lord, I address your lordship on this, that, my lord, a person who is residing, who has sold the building as a residential unit, on the understanding that it shall for all intents and purposes be used for a residential purpose, whether, my lord, your lordship would permit a person upon purchasing the portion, my lord, bought by him, to lock, stock and barrel remove all barriers. My lord, the structural stability, I am on the floor above. The structural stability is impeded. One.
But Acharya, those things would have been seen by the corporation when they.
I'm grateful. I have addressed two representations, bringing on record everything. My lord, the order which has been assailed before your lordship is apparently a perverse order. Why? Because they have refrained from taking into judicious consideration the materials which I had indicated to them, and my lord has taken into consideration only one fact. What is the fact? I have converted it into medicine shop, or I have utilized a portion of the garage, and therefore my portion be regularized, his portion be regularized. My lord, I am principally, my lord, elementary, my lord, I am submitting this to your lordship. This portion which is complained of, admittedly, is a residential part of the building. There is a completely separate entrance. I live on the floor above. He has lock, stock and barrel removed all walls inside the, and it has been converted into a big hall. Big hall, my lord, where there is no barrier. There is nothing apart from maybe a washroom. The kitchen, the bedrooms, every wall has been demolished. My lord, what happens is, my lord, the third floor persons, apart from anything else, they are in jeopardy. Where have I stated it? I have stated it before the authorities in my representation, detailing every fact. First representation of 16th May 2024, which is a part of the record, detailing all facts. Thereafter, my lord, it was revisited by the authorities. I once again address a representation saying that previously I have given a representation, please look into my contentions. My lord, with greatest of respect to your lordship, the order impugned does not...
Conversion has already taken place, right?
My lord, conversion has not taken place. The conversion has been permitted today. That is under challenge before your lordship.
So this could have been challenged in appeal also.
My lord, that could have been challenged, but if it is patently in violation of principles of natural justice to the extent of non-consideration of facts which ought to have been considered, then, my lord, your lordship,
that can be looked into by the appellate court.
My lord, I respectfully submit this to your lordship. If I can prima facie demonstrate to your lordship that the authority, while coming to the...
What is stopping you from filing an appeal?
My lord, the appellate forum is a long run process. My lord, first is I am a person who is residing there. My lord, if a gym goes on functioning with, my lord, loud music blaring, my lord, that has to be arrested somewhere. That has to be, maybe it is my duty as a lawyer, my lord, to assist the court by pointing out 435A permits them. Even a non-residential building can have it, let us assume. But, my lord, with certain riders, my lord, please look into section 424. It contemplates, my lord, the tranquility of the area. It contemplates the peace of, my lord, the persons in the neighborhood. My lord, today, I am being subjected.
Acharya, I'm not able to understand that what is stopping you from filing an appeal.
My lord,
first you have to tide over that.
My lord, whether, my lord, I respectfully say this in this, my lord, in my most humble way, my lord, that, my lord, whether it is an efficacious remedy, and whether, my lord, your lordship will shut me out just because there exists an alternative remedy. My lord, alternative remedy is always not a bar.
That we all know, Mr.
My lord, alternative remedy is always not a bar. If I can prima facie demonstrate to your lordship that, my lord, existence of a alternative remedy here, whether it is an efficacious one, and if it prima facie appears to your lordship that, my lord, the order impugned which has been passed is bereft of any consideration of whatever I wanted them to consider. Whether your lordship will not relegate me to the appellate forum saying that the authorities have refrained, but it is a completely perverse order based on considerations which were extraneous, if I may say so, to the actual things which were supposed to be considered and which were supposed to have been raised by me. That is my only submission to your lordship, apart from anything else. Today, the position of law, as I have understood, is whether apart from entertainability and maintainability has been diluted by the Honorable Supreme Court. A writ petition may not be maintained but might be entertained also, and it is just the vice versa and just the reverse. It may be entertained despite it not being maintainable. So what I am respectfully submitting, kindly looks into the documents. If it comments to
show me the documents.
Here, look. The 2007 too. 124 আছে, page 124 লেখা আছে. Now please come to the impugned order first. That your lordship will be pleased to find subject to correction at page 306. Second volume.
Yes.
This is the consideration at one page. Complaint raised against conversion of residential to gym as shown in the demarc. There are some shops in front. Area of shop is this. PR stated the flat has been purchased at second floor, now used as gym. Person responsible prays to allow retention which does not create any hazard. In my observation, the premises are not absolutely for residential purpose. They are shops in the ground floor. Moreover, the parking space is converted to shop and first floor is converted to mercantile use. It is not conversion. It was always for mercantile use. Some photographs are submitted, the pet show clinic, etc. Considering the statement of I am inclined to pass to retain. Now, I'm not pausing here. Now, please come to my detailed representation, which they have received. 16/5/2024.
So you have a shop on the ground floor.
Yes. The shop was all. Shop is. Please see page 243. Addressed to the authorities on 16th of June 2023, which I reiterate once again after the intervention of this honorable court.
Nothing. Yes, Mr. Bhatt.
Please see page 243. I reiterate 16th May 2023, which was filed with the building department on 16th May when the last hearing was held. On the last hearing, I was told by you that the hearing, however, again, a notice has been issued. During the course, I was told by your office that necessary stop work will be issued against running of gymnasium, and I narrate the entire facts. And my previous representation, Milord, is at page 228. Where at 229, Milord, these are the points which have been raised by me. Please come to 229.
You can raise all these points anywhere.
But these points have not been considered. I put this question entirely to myself, Milord. If these points, Milord, it fell on deaf ears.
Mr. Bhattacharya, the running of the gym in accordance with Schedule 5 is allowed in a commercial building. Running of a gym in accordance with whatever the schedule is, that's allowed in a commercial building.
In a non-resident, in a residential building, non-residential use has been permitted.
Correct.
Because running of a gym, according to the corporation, is non-hazardous.
Correct.
I have to admit that fact. No, this is a proposition that has not been, that has not weighed with the authority.
You should challenge that.
Well, that is in this proceeding, Milord, maybe it did not dawn on me, my lord, please see page 229, whether these have been considered, whether these issues which have been raised have been considered.
Nothing has to be considered as far as the commercial property is concerned. The conversion, this property itself has a lot of commercial activities going on. So even as
There
far
are
as the
lot of commercial activities
pet
down.
shop,
Yes, there's a pet shop.
there's
Yes.
a pet shop, there's a clinic, there's a medical store. Now, as far as the second floor is concerned, if you would have shown something which appeals to the conscience of the court, which is not permissible, then I would have interfered in here. I would have said, yes, the commercial activity which has been allowed is not something which is permissible in
And
the
the
property.
deed of sheer contempt is residential use. Of course, I can argue that because the deed is
correct.
But if I have to adjudicate that is
Suppose you buy a property today. You're not saying it's an investment you have done. Now you want
that Mr. Banerjee does.
You also do it.
Investment.
Mr. Bhattacharya, you think I don't know? So you buy a property. So you can convert that. You can use it for a commercial. Suppose you are getting less rental in a residential property. You can convert it to a. But what is stopping you from going and challenging this order before the appellate tribunal? You tell me one thing which shocks my conscience where I'll say that I'll allow this. You have an appellate forum for this. You go.
My right to sleep is encumbered.
No.
Sir, I cannot sleep peacefully.
Mr. Bhattacharya, you have not been sleeping since 2023.
Literally so.
For last 2 years not sleeping, don't sleep for a few more months. You carry this in appeal. There is no point.
Your Lordship is delegating me to the corporation authority. My Lord, I do not know whether there is a contemplation, my Lord, provision regarding, my Lord, delay. 416 says, my Lord, 30 days. My Lord, I am not, my Lord, recording anything. Your Lordship will, my Lord, kindly condone that aspect. 416, my Lord, provides for 30 days within which I have to take out or prefer the appeal, whatever.
My lord cannot condone that. My lord can say, my lord, that will be looked after, my lord, by the appellate forum.
Oh, he is again going to take that point there.
The condonation I can't do of that. You
Condonation can't be
that
done
is something.
There is something called section 14.
Learned counsel for the petitioner has preferred
That has permitted me, you know, that period has to be
petition challenging the order dated 20. Yes, Mr. Ghosh, 24/5/2024. Wherein the corporation has allowed deviation with change of use on payment of fees under section 401 and 416 of the KMC Act. Full stop. The said order is an appealable order before the Municipal Building Tribunal. Full stop. You'll withdraw it or I have to relegate it?
No. It's a withdraw.
Is an appealable order. Which which paragraph?
Milord, 35 of Milord, the unreported decision. 35.
What portion of the text am I free?
ऐसे कर देना फिर वो मत लिखो has challenged such and such so and so. It is a contention of the petitioner that he has made various representations and the same were not heard by the corporation before passing of the impugn order. He states that that principles of natural justice were not complied with before passing of the impugn order. Full stop. Learned counsel for the respondent appears and takes a preliminary objection that the order under challenge is an appealable order before the tribunal, building tribunal. Full stop. He relies on a judgment of this court passed in APOT 244 of 2022, titled as Muhammad Ali Mirza versus Calcutta Municipal Corporation, dated 19/10/2023, wherein the division bench of this court has held
Done. I'm taking lordship's deed.
Yes, yes.
এখন cost চাইছে
তাহলে থেরাপিটা আমরা ভালো করে দিতে পারবো।
वो डाल देना ये paragraph 35 full stop. In terms of the said order, this court is not inclined to condone the delay and leaves it to the wisdom of the statutory the tribunal to look into the aspect of delay, full stop. Since the petitioner since there is a alternate efficacious remedy available in law, this court does not wish to exercise its discretionary powers under section 226 of the Constitution and relegates the petitioner to the tribunal, building tribunal, in terms of section so and so of the Act. Full stop. With the above direction, the presented petition is disposed of. The tribunal will look into it.
Tribunal will not, so far as because we are approaching the tribunal after your lordship's
that's
intervention.
for the tribunal to decide.
The tribunal will not, of course, go into the question as to, since we are prosecuting this matter, that period has to be.
That's for the tribunal to decide. Section 14 says so. Section 14
your
says so.
lordship may, in your lordship's order, make one observation so that the tribunal does not say that you have not come within 30 days, you go.
He doesn't deserve a blessing,
The tribunal should be considerate
Wait.
to the fact that the petitioner had approached this court.
Millard, may I join issue there once?
No,
Millard,
I'm not going to bar him from
only two sentences, Millard. I will not disturb your lordship, Millard, more than that. Millard, section 14 says, bona fide if someone pursues his remedy, kindly seize his bona fide in paragraph 43. And then I will leave it to your lordship. Paragraph 43 of the writ petition, Millard, he has said.
I'm not going to make anybody remediless. Then I'll entertain this petition and then I'll decide. I'm not going to make anybody remediless. That is the last thing which this court wants to do. क्या लिखवा रहा था?
This was in
The
desperate.
tribunal should be considered of the fact that the petitioner had knocked on the doors of this court in dealing with the aspect of limitation, and that the petitioner had bona fidely approached this court under the impression that this court is empowered to deal with the said impugned order, full stop. Under the said belief, the tribunal should be at liberty to consider the aspect in terms of the above.
Seems Millard, I dug my own grave. Grateful to your lordship. Grateful.
বরং তোর এটা না, এটা তোর দিয়ে দাও ভাই।
Yes, Mr. Mukherjee, your appeal.
I appear for respondent number 5 to 11, my lord.
Petitioner, who's for the petitioner?
I am for the 12 and 13 lordship.
Settle it.
Two things, my lord. Already challenging this order, we have preferred a mandamus appeal before the honorable division bench, which is appearing today itself. Also, my lord, there are two appeals, my lord. I will be humbly beseeching your lordship, if my lord kindly adjourns for the time being, then the appeal will be taken up for the today itself, my lord.
So what appeal you have filed?
But there are two orders, my lord. The initial order for which this writ petition has been filed for implementation of that order, as well as your lordship's order. The corporation has stated that they will be initiating a demolition proceeding and serve a notice. No notice was ever served among us, and we are not aware of any demolition proceeding. Challenging which we have preferred the appeal before the court. Well, we came to know after
When did you file that appeal?
During pendency of
the first order was passed on 16/1/2024.
My lord. Yes,
Right?
my lord.
You have preferred an appeal
Yes, that is
1.5 years back.
no. Recently, my lord, after coming to knowing of the reason, I was not representing the writ petition earlier occasion also. After serving this notice, when corporation visited the premises for taking steps for deposition.
When did you file the appeal?
Last week, my lord.
Last week. Is there any stay?
Well, that will be taken up for hearing for the course of the day itself, my lord.
Doesn't matter. Yes.
No hearing, nothing. Well, question of hearing does not come.
Unauthorized
I
construction.
proceed under subsection 8 of section 400. There's no concept of any hearing in that.
That's right.
Now, the basic fact is a 3-storied building has all on a sudden become 6-storied building. Adding 3 more floors. Malad, call for a report. Malad, we have informed police because unless it is evacuated, the residents of that building is evacuated, we cannot proceed with the demolition. So, police has been informed.
Under section 400.
Malad, the last 4 lines at the time the premises was found almost occupied condition.
Mr. Mukherjee, order has been passed 1.5 years back.
Yes, yes.
All this is being
And
done.
Malad, that day I was telling Malad, there's something said, something unsaid. This is something unsaid. Malad, anyway, we are proceeding with the demolition.
I will humbly pray my kindly action for the day itself, my lord. The appeal will be taken up today itself, only, my lord. We have mentioned before the court, the honorable division bench, where division was kind to see the urgency and take it here today itself, my lord.
Let this matter be listed after. You are taking action. Nothing to be nothing to be recorded.
Police has gone to evacuate so that the demolition can
At the
proceed.
request of the petition, let this matter be listed after. In the meantime, you do whatever you have to do. 20th of June. At the request of the learned counsel of the petitioner, let this matter be listed.
Oh, great.
A report is taken on record. वो लिख लेना तमाम report is taken.
But I am for the petitioner.
I am for the
May I
private
say-
respondent.
May I say, my lord, the desperate attempt of the municipality by submitting a report on the last occasion saying that demolition has been completed, wherein only the parapet wall was being touched. Entire, my lord, ground floor, there is no sanction plan. Additional 2 floors were being constructed without sanction. Your lordship directed this thing can be done, my lord, and report today. My lord, my instruction specifically, my lord, last night also only the parapet wall of the my lord, roof is being touched, nothing, my lord, being done thereafter, nothing.
G+1 building, my lord.
G+2.
No, G+1.
I think they are very much well known about that, rather than us. It's better they should do.
My lord, the demolition order suggests that it's G+2.
1+1, one room in the second, first.
Mr. Mukherjee,
My lord.
where's the order?
Yes, my lord, if the lordship takes up page
Picture of the demolition.
page 27 of my lord's brief, kindly once looks at.
Page 27.
Yes, my lord.
Yes.
1 to 4, my lord, they have categorized what is the unauthorized portion.
So it is G+2.
G+2. So, my lord, it is their order, my lord, which is suggested, my lord, it's not from the
See, the
department.
second floor is 240 square feet. What I have learned, 240 means one room is there.
No,
And so-
unauthorized construction is 240 square feet on the second floor.
Unauthorized.
Yes.
Unauthorized. And G+1 is that unauthorized to the first floor is 760 square feet.
Yes. So what action have you taken?
I
Mr.
have taken these actions. This
Lord, I must say,
Yes,
this
yes.
similar photograph, my lord, which has been placed before the lordship on the last date.
Twice occasion they went.
we have
For
went,
demolition
we
they have
have done the demolition for twice.
No, this is nothing. This is eyewash.
Your lordship discarded it on the last.
Eyewash. This is absolute eyewash.
No, my lord, I will do. But we have to take some time. For
No, you take time, but at least do the.
No, I am
Don't-
not saying that it
Don't
is.
show this kind of picture, Mr. Banerjee.
I will
Please.
talk to them and I will say. But
Lordship-
they have said
Learned
that
counsel
two-time
for the
demolition was done.
learned counsel for the
Lordship,
respondent.
may I- Lordship, may I-
Just a minute. Learned counsel for the respondent, Havra Municipal Corporation seeks and is granted further time of how much time?
6 weeks.
4 weeks. 5 weeks. 5 weeks to file a compliance report in terms of order dated 23/4/2025. At least carry out the demolition.
And another, my lord,
Yes, you tell.
Lordship, we have also preferred one read application
Very good.
against this demolition order.
Very
Lordship.
good.
Lordship, can it be listed with this application, Lordship? Let the matter be heard at analogous.
It will come on its own turn.
Lordship, then, Lordship, my REIT application will become infructuous. Lordship, what's happened, Lordship? We have also made an as-made plan that is still pending. There is no election being conducted
do you have
in the
a-
Howrah Municipal Corporation,
You
Lordship.
have a sanction plan.
No, Lordship, what happened, Lordship? Due to the medical agency,
Not
I know,
even
Lordship,
ground-
we are admitting that there is no sanction plan,
All right,
Lordship,
we'll-
but it's a old building.
Learned counsel,
1933
learned
is the year
counsel for the
1933 building.
respondent. Learned counsel
The
for the
building of the petitioner is of 1933.
It's an old building.
It is old building, 1933, and the building of the petitioner is also 1970. Both of the buildings, both of them objected against the unauthorized construction.
demolish both if they are
Yes, I
unauthorized.
will have to, because both have unauthorized buildings.
I do
They
have my sanction
they-
plan in
Demolition
1975.
notice has also been
Mr.
passed.
Banerjee is not.
Lordship,
I
the
will
demolition
not say
notice-
anything.
Mr. Banerjee,
my-
If they have a sanction, they can come to the court.
Lord, I have.
Lordship,
Mr.
the
Banerjee.
corporation has already passed an order against them also for demolition.
We have already passed an order.
Lord, that they have said I have deviated in 75
Mr.
sanction.
Banerjee, you are saying the construction is 1933. What is it?
33.
No, Lordship,
33.
it's an old building.
A joint hearing, both the parties remained so and so during the hearing. So and so admitted that he erected entire first floor, second floor without sanction plan.
Yes, no sanction.
Later on, he submitted a plinth so and so in 1959.
59. 93 and 59.
Lord,
Why are-
recent-
why-
This is also before 90.
Why are you trying to save them?
Lord, if Mr. Banerjee,
Saying that both are domestic buildings, and now if we
Domestic buildings,
madam, if we go and
the admission in
go
front.
and see the Howrah, entire madam, we have to be killed.
It has to be. All these
Because
unauthorized construction which has come up.
There are some
Lord, these
maximum
two
buildings are
additional
without sanction.
these two additional floors,
Yes,
Lord, there are
no.
order passed by this honorable court.
I never
Mr.
These
said
two
that.
additional floors
And
have been
for that reason, I blamed in Howrah also.
Lord,
Where
And demolishing each and every
you
building.
have to.
coordinate bench in this matter, Lord, the coordinate bench recorded during
Justice
pendency.
Sinha's order is there.
Yes, during pendency of the
Yes, we
contempt
have-
application, Lord, they have constructed.
We will demolish, no problem.
You
If
have
Honorable
to.
has given us 5 weeks time, I will come with the compliance.
Learned counsel for the private respondent states that he has filed writ petition number
Lordship, 19292, 2024.
so and so challenging the demolition order passed by the Howrah Municipal Corporation. Let the same be listed along with the present writ petition.
Grateful, extremely grateful.
List after 6 weeks.
Great.
6 weeks, Mr. Manager, 6 weeks. Say, I will list it after 6 weeks, 5 weeks to file your affidavit.
I mean,
And matter is returnable 6 weeks.
The rest of the matters after lunch, yes. After 6 weeks, give a date.
There is a division bench.
2-7. 2-7.
I'm grateful.
Division bench is not there. Justice Banerjee is not well, so he has not come. So we'll
Your Lordship, under the compelling circumstances, may I permit to mention a matter of Rule 9 in the running in the daily list of the Honorable Justice Amrita Sinha.
Not
Your
at this time. Mentioning is in the morning.
Yes, Your Lordship. I will permit to.
Yes.
And for the petitioner in this matter, I have been just briefed in this matter, and as per your lordship's earlier direction, there was the report, my lord, that has been directed to be filed in the form of an affidavit. That has, my lord, just been handed over to me, my lord.
Permitted to file the report, your lordship. And for the Kolkata, led by Mr. Sridhar.
I may, my lord, need to, my lord, take out an exceptions with regard to this report. This has just been, my lord, handed over to me.
Just take down. The report is filed on behalf of Calcutta Municipal Corporation. The same is taken on record. Learned counsel for the petitioner seeks time to file his exception to the said report. Seeks how much time?
I will not, after, keep it after vacation. By that time, my lord, I shall complete.
3 weeks time to file his exception to the said report. Let this matter be listed on 24th June. What?
But I am appearing for.
I'm grateful. Sanushri has already said that.
My lord is fixing any date, my lord, or just directing it to appear after. I'm grateful, man.
Much obliged. 24th June. Lordship, if the exception can be given week ahead, your lordship, then we can also get ready.
Hand over the
I'll try to.
exception before.
I'll try.
I appear for the Kolkata.
Lordship, I'm for the petitioner. Can you please grant me short passover? My senior is on her way.
Passover. Have you filed the exception?
I have not received.
Yes, we are. We are filing the exception.
Copy.
Well, immediate requirement, let me look into what is the report, because it's a short issue involved here. He's complaining about unauthorized construction in respect of particular premises. The construction is being registered in different premises, not in the premises which has been mentioned, and that too with a sanctioned building plan. Therefore, that my report is only to that extent. Therefore, I don't know what they have mentioned in their exception, because of 529, the premises number which have been mentioned. Now that has been subdivided into 5 premises, A, B, C, D, in all these, and the construction has been made at a different premises, and that too with the sanction of the building plan. We have not reported as yet, but so far as that construction is unauthorized.
You need.
Yes, ma'am. I have got just now the report.
Learned counsel for the petitioner has filed the exception to the report filed by the Calcutta Municipal Corporation. The same is taken on record. Mr. Ghosh, who appears for the Calcutta Municipal Corporation, seeks time to go through the said report. Let this matter be listed.
My lord, I am for the petitioner, lordship.
Yes, madam.
Lordship, I am for the petitioner, lordship. I am tendering my apology.
Yes, tell me.
Lordship.
From the criminal side to the civil side.
Lordship.
You have traveled from the criminal side to the civil side. Yes, tell me.
Lordship, the petitioner filed a writ application previously.
He wants some time to go through the report.
Yes, lordship, but we have to file an exception to that report, lordship.
That's what he wants to go through the exception. Let this matter be listed on 20th of June.
20th.
20th of June.
Careful to me.
Grateful.
I forgot your name. What's your name? I forgot your name.
Shabana Hassin. Lordship.
But we are for the municipality.
I am for not it, my lord.
I am for the petition.
I got the instruction, my lord.
Who appears for the director local bodies?
Yes, my lord. I am
Yes.
for appearing. My lord, kindly. Sure. রোডগুলির কোনো পোস্টই নেই, এই জন্যই রিফিউজ করেছে। রোডগুলি রোডগুলি
What kind of report is this?
My lord, yeah, my lord.
What kind of report is this? You are denying is
My lord, there has been no sanction post, my lord.
what sanction post? He has worked against a sanction post.
Unsanctioned.
What documents have you given them?
My lord, they have actually this post was not sanctioned by the DADLB.
My lord, at all not, my lord. This is completely, Lordship, kindly see for a moment, page 32.
You are making people run
Page
from
32,
pillar to
completely
post.
wrong submission and misleading the court, my lord. My lord, I'm sorry to say, my lord, they are misleading the court. Both.
But they are not sanctioned.
Both they are misleading the court. Lordship, kindly see, my lord, for a moment, page 28, my lord. Sorry, my lord.
Page?
Page 28 first.
28.
Page 28. My lord, this letter was issued, my lord, 11th of April 2019 by the Director of Local Bodies, my lord, to all chairpersons, commissioner to submit their staff statistics. My lord, I am reading, my lord. As you are aware that the UD and MA department requires every year a complete statement of staff statistics in respect of all UL, that means urban local bodies in West Bengal as on 1st April of the said year for release of salary DA grant. Accordingly, you are requested to kindly submit the required list as on 1st April 2019 in the following format to this office on or before 30th April 2019 or through email so and so. Now, Lordship, pursuant to this letter, Lordship, kindly see, my lord, that next page, my lord, page 29, my lord. Got it, my lord, page 29.
Yes.
My lord, page 29, my lord, issued by the chairman, my lord, pursuant to that reply, my lord.
Yes.
20th April 2019. Lordship, kindly see, sanction post 310.
Yes.
Vacancy to 203. Actual staff pattern 107, my lord. Now, Lordship, kindly turn, my lord, page 30. This is the list, my lord, page 30. Bodhavati Municipality, Shafuli, Hooghly statement of sanctioned staff statistics as on 1st April 2019. This has been issued by the municipality, my lord, chairman of the municipality. Now, Lordship, kindly see my name, my lord, page 32. Serial number, my lord, 59. Lord, it is, my lord, kindly, my lord, pardon me, my lord, this is black poster, my lord. Bhola Baspore, petitioner herein, road coolie, date of joining, my lord, Lordship, kindly see 1st April 1984. Thereafter, my lordship, can you say approval order number so and so, pre-78 post and the date of birth, my lord, group D and his pay scale, my lord. Now, lordship, kindly see, my lord, he has received, my lord, the entire the benefit, my lord. I have annexed here is, my lord, the bank statement as the salary issued by the, my lord, the municipality, my lord, after disbursing the amount, my lord, by the director of local bodies, time to time till the date of retirement, since the date of appointment, my lord, I have received the entire salary like other permanent employees. Lordship, kindly see my bank statement. Page, my lord, it starts from page 24, my lord. Page 24, Lordship,
page 25, my lord. Lordship, kindly see, it has been recorded, my lord, NEFT 3rd of December 2019. My lord, I have annexed, my lord, to, my lord, Lordship, kindly see, credited 26,889. Thereafter, my lord.
Wait a minute, give the date. Are you in a hurry?
Yeah, sorry, my lord. Sorry.
Which date?
The date, my lord, kindly see, 3rd of December 2019. Left hand side, my lord, date.
Page 25.
Page 25, my lord. Left hand side, bottom.
3rd December 2019.
Lordship, kindly credited 26,889. NEFT RBIS Sri Rampur. Thereafter, Lordship, kindly see, bottom 4th of January 2020, 26,889. This is the, my lord, full salary after revision of all the allowances, my lord. Next page 26, my lord.
Yes.
My lord, 2nd April 2020, NEFT, Lordship, kindly see, 30,096. Then again next, my lord, 30th April 2020, 30,096. Then thereafter, my lord, Lordship, 5th June 2020, 30,096. This way, my lord, he has received, my lord, till the date of retirement, my lord, the entire salary, my lord, along with other benefits, my lord, which has been, my lord, disbursed by the paid by the municipality, and that amount has been disbursed by the, my lord, Director of Local Bodies. Now, Lordship, kindly see, my lord, after 36 years of service, my lord, they have issued me a letter, my lord, Lordship, page 34. Lordship, kindly see, this has been issued by the chairman. Page 36, my lord. This is my superannuation letter. Page 34, annexure P4.
Yes.
19 February 2022. Bhola Baspore Road Kuli. My superannuation 30th November 2022. So, my lord, I have thereafter, my lordship, kindly see next page, page 35. After my superannuation, my lord, the municipality sent my service book for verification. Now they are saying this is an unsanctioned post. Lordship, kindly see Bhola Baspore, 2nd Road Kuli, retirement 30th November. Thereafter, my lord, page 36. After receiving of this letter, my lord, what was the query of the Director of Local Bodies? Lordship, kindly see, on examination of service book of Sri Subhash Chatra and Sri Bhola Baspore, it is found that their profiles are not approved in ISMS portal of Bodhavati municipality. Now they are saying that post is not sanctioned. But only their requirement was that my name was not, my lord, appearing in the ISMS portal. When the municipality, my lord, upgraded that, my lord, that portal has, that ISMS portal that has been approved, my lord, now they are coming, my lord, with a new plea that I'm not, my appointment was not made against sanctioned post. But I have, my lord, already, my lord, submitted from page 32 that my appointment was made against the sanctioned vacant post.
What have you filed? You don't apply your mind. I'll call the Director Local Bodies. If this is the way affidavits are filed.
Actually, what happened, my lord, they have sent a soft copy, and I just get a printout from that, and just as your lordship, that's why I'm just placing for, as your lordship pleases, my lord, kindly, I'll affirm this.
Take down.
Well, we have already uploaded the IOPSL portal and sent it to the local.
A report is filed by the Director Local Bodies. The report indicates that the Director Local Body has failed to apply his mind to the said report. The facts mentioned in the report are absolutely contrary to the facts of the present writ petition. It is stated in the report that the petitioner who was working on the post of road coolie is not a sanctioned post under the Baidyanathi municipality. And since he's been working on an unsanctioned post, no salary can be fixed. From the facts of the present case, it is evident that a letter dated 11th April 2019 was issued by the Director Local Bodies to all the municipalities wherein they had asked for the details of the employees for release of their salary, DA and other grants. In response to the said letter, the Badyabati municipality, wide letter dated 20th/4/2019, had provided all the relevant information. And from the record, it reveals that there are 310 sanctioned posts in the municipality. A list of the sanctioned posts are annexed with the writ petition. From the record, it reveals that the petitioner has been working against the post of coolie since 1/4/1984. Full stop. It is learned counsel for the petitioner also points out that the municipality had already provided the information regarding petitioner's retirement to the director local bodies. Director local bodies had sent a letter dated 29th July 2024 to the chairman Badanath municipality seeking verification of fixation of pay in respect of the petitioner, wherein they had mentioned that the profile of the petitioner is not approved in the IOSMS portal of Badanath municipality. They had further requested for the service book of the petitioner for verification. In the earlier communication, no such plea that the petitioner has been working against an unsanctioned post and that he is not eligible for pensionary benefit had been taken by the director local bodies. Further, from the record, it reveals that the petitioner has been receiving salary from the respondent corporation,
municipality,
from
respondent municipality,
from time to time, as reflected from the bank statement of the petitioner. It is disheartening to note that a person who has rendered a considerable amount of service of more than 36 years, is being made to run from pillar to post, and the director local bodies is raising frivolous and unsubstantiated roadblocks in releasing the pensionary benefits. It is expected of the director local bodies that they shall go through the averments of the writ petition and file a better report with application of mind, a report by way of an affidavit after applying their mind to the said facts of the case. Full stop. the said report shall be filed within a period of 2 weeks in terms of the observations made by this court. Let this matter be listed on so and so. Before that, the learned counsel for the respondent municipality states that the necessary the petitioner's profile has been uploaded on the
Already sent.
IOSMS portal, and
We
all
also sent the
necessary
satisfied to the, we also sent the
compliances in terms of uploading of the petitioner's record on the IOSMS portal as well as the service book of the petitioner has been sent to the director local bodies. It is expected of the director local bodies that they shall apply their mind and process the case of the petitioner as expeditiously as possible and file a report before this court within a period of 2 weeks, list after 4 weeks.
Milord, can you give a particular date, Milord, a specific date, Milord?
Give a date on 24th of June. 24th June.
Wait.
And tell your director local bodies, I'll call him. If he's not going to apply his mind, you can't just file these kind of reports.
24th June.
Road coolie. Road.
24th. 24th.
A report is taken up.
Milord, ask my learned friend, Milord, to supply me a copy of the report.
What will you do with the report? Give a copy.
Milord, next matter is also the same, but Milord, Supratim Dhar, as I came to know, Milord, he has returned the brief, Milord.
Come here, come here. Come here.
Same matter, Milord. Same municipality, same.
Mr. What is your name?
Shoikat Sen, my lord.
Shoikat.
Shoikat Sen. Shoikat Sen.
Choitat.
Shoikat.
Shoikat. Shoikat Sen. Mr. None appears for the respondent state. Mr.
We are for the municipality.
Shoikat Sen, who has entered appearance in a similar matter in writ petition number so and so, is requested to assist this court in this writ petition too. His appointment shall be regularized. Full stop. He seeks and is granted 3 weeks time to file his
9836
report in the form of by way of an affidavit. Full stop. Let this matter be same date.
I don't know.
You have already done.
Yes, already.
Milord, in this matter, Milord, the profile has already been uploaded.
Learned
Yes,
counsel
profile
for
has
the
already been
respondent-
Earlier occasion, Milord, it has been
Learned
recorded by
counsel for the
minor.
respondent municipality states that the petitioner's profile has been uploaded on the IOSMS portal and necessary documents have already been forwarded to the director local bodies to take a decision in the case of the petitioner. Full stop. It is expected of the director local bodies that he shall expeditiously take a decision on petitioner's case and file a report within a period of 3 weeks. Report by way
Kindly,
of an
my lord.
affidavit within a period
Let
of.
it be appear on the, my lord, same day.
Same.
Same.
Let this
Grateful.
matter be listed. You have understood what?
Grateful.
Ask them to file a report. Get it done.
Yes, madam.
My lord,
I'll try
after
my level
36 years of service, my lord,
I'll try my level.
grateful. My lord.
My lord, in item number 14, my lord, I am for the petitioner. May I file the affidavit of service?
Lordship. There are other parties also. Before proceeding, my lord, I take the point of maintainability, Lordship. Can you see the prayers?
My lord, may I place my case, my lord? My lord, the petitioner is a lessee who has purchased a land, who has taken lease of a land from the West Bengal Housing Board. My lord, if your lordship can kindly see the
Is the municipality involved in this?
minus municipality, what I want, my lord, may I show the pictures, my lord? Over the time, they have constructed roads, which now the roads are about 2 or 3 feet above the, my lord, house. And the petitioner, my lord, is an octogenarian citizen. My lord, kindly see, this is a picture 2 days back. 2 days back.
Hey, why did you put all these pictures and other things? Why are you handing it over to the court like this?
No, subsequently, my lord, I have everything mentioned in the writ petition.
Where
If
are
your
the
lordship
pictures?
once I can submit this with an affidavit.
Tell me what is the case.
My lord,
I'll hear Mr.
my lord,
Nayak.
case is, my lord,
Let him speak. Let him speak.
my lord, the petitioner is a lessor who is, my lord, lessee under the West Bengal Housing Board. And my lord, if my lord kindly takes up page 13 of the writ petition, there is the scheme. Under the scheme, my lord, the petitioner has taken a plot. Now, my lord, if
Page
13 starts the scheme, the housing house and plots information brochure. This is the information brochure, my lord, which was published in the website.
Sir, page 30 is not the information brochure. I don't know.
My lord, annexure P1, page 13, or page 15, my lord.
Yes.
My lord, if my lord kindly sees page 15, point number 2, category MIG2. My lord, got?
Yes.
My lord, if kindly my lord sees provisions, roads, pathways, and pakka surface drains. This was the advertisement which was given and put up in the website under the scheme of the West Bengal Housing Board. Now, my lord, if kindly my lord takes up page 19, that is the plots and flats and houses at the satellite township. That is a project of West Bengal Housing Board. Page 22, my lord.
Yes.
My lord, second paragraph, why exemplary? Exemplary cost has been paid, my lord, by the petitioner. But why exemplary? Because, my lord, Sorsuna is an ideal place for a satellite township. The wide open space and healthy environment, my lord. Healthy environment are the salient features of the complex. 120 feet wide Diamond Harbour Road is nearby, only 3 kilometers from the location. Park, playground and market within the complex will make it self-sufficient. Township metalled road, my lord, metalled roads all around, and the drainage system are the added facilities. Various bus routes will sustain the smooth traffic flow to come for the city center. My lord, this is the sole reason and purpose why, my lord, the petitioner along with others have wasted their all entire hard-earned money to buy a plot. Now, my lord, both aspects of man's environment, nature and man-made, are essential well-being and to the enjoyment of basic human rights. Makes the right to life itself. It is stated under the United Nations Stockholm in 1972, and then my lord, the class, I will not go into the details about the history and everything, but the main point is Article 21. It very much enshrines that right to livelihood. It is extended, my lord, to the well-being of a citizen. Now, my lord, a drain, which is already, it is written everywhere that it has to be a surface drain. Surface drains meaning the level of the drain and the level of the road has to be on the same level. But now over the period, my lord, over the passage of years, every year road is being metalled, and now what has happened, the road is about 5 feet above the house and the house is below. And even if that be so, the drain has to be elevated. Otherwise, my lord, if my lord kindly peruses the pictures, or if my lordship wants, I will submit an affidavit. On affidavit will come up. Now the drain is below the road, and all the waters of the drain are entering the house of the premises. The petitioner, my lord, is 82 years old, my lord, alone, without any offspring, without anyone. He is, on and off visiting hospitals because of this thing. He also cannot hire someone who will evacuate the water from this. The petitioner had made several representations to the municipality, to the councillor, to the all the respective authorities, housing board also. If my lord can kindly take up the representations, my lord, at page 36, my lord, of the writ petition.
Yes.
Subject regarding assessment, annual valuation of my premises, etc. My lord, may I read? I, senior citizen of 73 years and of middle class origin.
All right, I've understood. Yes.
My lord, I take the point of maintaining this is not even not public in this litigation, because his grievances may be very good. I am not on that. I am opposing his grievance. But prayers are not in connection with KMC in any manner whatsoever. It's a project to be developed. It may not be up to the standard, may have some very good reason to argue, to come up before the court, but not before this bench, lordship.
How this is...
And my lord,
has replied.
We are not representing.
Page 37.
What? After all the prayers,
Yeah.
lordship, kindly see the prayers.
That it is the responsibility of KMC. KMC is telling that it is since 36 years back. So therefore, we cannot do anything. There is some problem in the planning. Recently, 2-3 days back, my client, he is telling that he has received a letter, but he could not come up to me to give. If your lordship wants, I can also produce that letter, which was issued by Mayor KMC, directing the other departments to look into the matter and to see whether that drain can be elevated or not. And to that, the deputy engineer, they should be knowing it better. They should come up with that report that they are telling that there is a underground drain which is under process and it should be done within few weeks. But that has again been
Anyway,
6
there is
months.
no cause of action to come up before this court. Lordship, kindly see the page 37.
Yes.
He is referring later.
Yes.
That what West Bengal Housing Board has said.
Yes.
So they are not here, but this is the letter to the petitioner. Subject response to your alleged complaints. In response to your letter under reference, this is to state that during joint site visit with you on 6/6/22, it was observed the necessary land development works, construction of drains, are as per scheme was carried out by the West Bengal Housing Board before handover of the land plots to respective buyers, and said facilities are still existing there. Campus was handed over more than 36 years back. Development of drainage system and pathways, etc., as would have been required over the years, is no more the responsibility of the West Bengal Housing Board.
Yes,
No
ma'am.
further works in this regard can be taken up by West Bengal Housing Board. Also, the intervention is not possible from this end. Where KMC is alleged, quickly has replied, he was saying that KMC has said that is the duty.
They should come up with the letter. If your lordship wants, I will come up with that letter.
In hand
I am
has
submitting, I am giving an undertaking.
Either you withdraw this writ petition and file a fresh, better writ petition, or I'll dismiss this.
My lord, I shall come up with
or
an evidence.
Take down. Take down. Learned counsel for the petitioner has preferred the present writ petition seeking direction against respondent number 2, which is the seeking direction against respondent number 2 to strictly adhere to the contractual terms and conditions as stipulated in the lease deed of 14th of January 1986. Full stop. Learned counsel for the petitioner submits that the petitioner has entered into a lease deed with West Bengal Housing Board has entered into a lease deed dated 14th January 1986 with West Bengal Housing Board after Housing Board, full stop. The petitioner was allotted. What, you have taken a land?
Yes, my lord.
You have constructed also?
Yes, my lord. As per the scheme.
The petitioner was allotted the said land in terms of the lease deed and had carried out the construction in terms of the lease deed, full stop. It is the case of the petitioner that in terms of the brochure issued by, this is West Bengal Housing Board, right?
Yes, my lord.
By West Bengal Housing Board, the petitioner had invested in the said project at Sarsona Behela and had entered into a lease deed with the West Bengal Housing Board, full stop. The petitioner has been staying in the said property for the past 36 years. He states that the West Bengal Housing Board has failed to fulfill its promises in accordance with the brochure and the requisite drains and other facilities which had been promised have not been provided to the petitioner, full stop. The petitioner has not sought any relief against the Calcutta Municipal Corporation.
No, my lord, I have sought.
Full stop. Learned counsel for the Calcutta Municipal Corporation states that the dispute between the petitioner and the West Bengal Housing Board is a private dispute and that the corporation has nothing to do with the same. He states that the petitioner is seeking enforcement of his rights under the lease deed executed between the petitioner and the West Bengal Housing Board, full stop. Petitioner refutes the said fact and states that he has received a letter dated 18/7/2022 wherein the West Bengal Housing Board has stated that all the facilities have been handed over to the buyer and that they have been staying there for the last 36 years. 36 years, full stop. They further state that development of drainage system, pathway, etc. would have been required over the years is no more the responsibility of West Bengal Housing Board. The development of drainage system pathway is no longer the responsibility of Housing Board, West Bengal Housing Board. Full stop. Nowhere it is mentioned that the said development has been handed over to the Calcutta Municipal Corporation. The petitioner has failed to file any document showing that the project has been taken over by the Calcutta Municipal Corporation and that the terms of the lease deed which have not been fulfilled by the West Bengal Housing Board falls on the corporation, full stop. since it's a dispute between the lessor and the lessee regarding non-fulfillment of conditions as enumerated in the lease deed. This court is not inclined to exercise its discretionary jurisdiction under Article 226 of the Constitution, and thus the presented petition is.
My lord, may I submit only one
dismissed.
thing? My lord, may I submit only one thing? My lord, Audi alteram partem and nemo judex in causa sua. These are the basic fundamentals of my lord.
Sir, I'm not the end of your road. All right.
No, my lord, my only submission. Then my lord kindly gives me a leave to at least approach my alternative remedy which is available to me, my lord.
That's
Otherwise,
why I asked you initially, you want to withdraw it. You said you don't want to withdraw it.
my lord,
The first question I asked you, do you want to withdraw it?
my lord,
You said I don't want to
my
withdraw.
lord, may I come up with an affidavit? My lord, I will.
Either you
satisfy
withdraw
your
it, sir,
lordship.
or the order is there. You challenge the
Then my lord, leave to withdraw, my lord, kindly.
Don't take the court for a ride. I'm allowing it this time. I'll impose exemplary cost. You're a young counsel. Don't do this.
My lord, the petitioner.
Learned counsel for the seeks to withdraw the present writ petition. Same is dismissed as withdrawn. Last time. I'll remember your face. Next.
I'm grateful, my lord.
Unnecessarily waste the time.
Lordship.
Yes.
My lord, in this matter, I am for the state. Before NFN start, my lord.
Yes.
I will be seeking a leave to file an affidavit with regard to the allegations made therein, not in a affidavit of opposition, but a report in the form of affidavit with regard to the.
Who appears for Behrampur?
I find Arindam Das was there.
They have Behrampur. Have you handed over all the documents to the director local bodies?
My lord, the executive officer.
Where is your report?
My lord, the executive officer is on medical leave, my lord.
Who?
Executive officer is on medical leave of the municipality.
So there is some delay, my lord, to file the report, my lord.
Do you understand these people who have worked with you and you don't even release their salaries?
My lord, kindly keep date, my lord, in after summer vacation, my lord, we will file the report.
Well, this is their delay tactics, my lord. In other cases also, they do like this. And poor petitioner, she's suffering every day with her paralyzed husband.
Madam, what can be done?
She's also not offered.
What can be done?
Nothing, my lord. I'm just waiting.
Learned counsel for the respondent municipality states that the executive officer is unwell and thus they are not in a position to file the report. Full stop. This court is astonished to note that if one person is unwell, the entire municipality ceases to exist and function. Full stop. Be that it may, this court grants 2 weeks time to the respondent municipality to file its report in the form of an affidavit. Learned counsel for the state prays for similar relief. Full stop. Let the affidavit report be filed in the way by way of an affidavit by the state before the next date within a period of 2 weeks. Let this matter be listed on 23rd of June.
Item number 16, my lord, I'm praying for a short passover on behalf of Kolkata Municipal Corporation. That's because
This is the application for representation, consideration of representation, whether the possibility of lift or not. Only there they have to consider my representation.
matter is
Maybe, madam, the last 8 months, my lord, the cancer patient, a 74 years persons staying 4th floor without having any lift.
Argue your case.
My lord,
Argue.
my lord, only,
No, argue it. I'll see that.
my lord, that's
He's asking for a Passover. What is the problem?
Lord, sir.
You argue, I'll take care of it.
No, I live to your lordship.
Not today. Not today.
17 also, my lord, he is appearing, my lord, for KMC.
Mr. Ahmed, what is it?
Well, the other day, yesterday, your lordship, they had asked for a time.
Yes. Where is Mr. Banerjee?
Well, the
I appear for the state lordship.
the building, my lord, was constructed in 1934 out of, my lord, Chud and Surki. Now, all of a sudden, my lord, in 2005, sometime in January, it occurred to them there has to be a reconstruction of a 95-year-old building. Now, my lord, I'm occupying the ground floor. I saw, my lord, the preparation of scaffolding, and I asked some of the people who were there, some of the local goons. They said, we are going to construct 2 floors above, and if you try to object, we'll take care of it. My lord, then thereafter, what has happened is this.
Mr. Ahmed, we'll have it on Friday.
Friday, my lord, I'll be leaving. Only thing, because now, my lord, we had filed it in January. So, my lord, by now, my lord, they have more or less completed it. I am not on that. Now, the thing is this, they cannot get away with by the construction, making illegal construction. My only submission with your lordship is, my lord, direction, it will not prejudice anyone. Let there be a joint inspection by my engineer as their KMC's engineer, and a report be filed thereof. And the other prayer I'm making with your lordship is this, let them produce a writ of certiorari be issued, or by production of the records under which this the permit was granted, or the sanction was made. The sanction was made by 3-2 EA.
Lord, I am
only for minor repair.
I am the owner of the building, my lord, and I constructed the floor with the sanction plan. My learned friend's client filed a suit before the city civil court, obtained an ad interim injunction. We went there, contested it, it was vacated. Injunction restraining us from constructing, particularly, my lord, and that injunction order has been vacated. My lord, this writ application, my lord, has become infructuous after they filed the suit.
So, have you carried out any unauthorized construction?
No, my lord, this is sanction plan is there.
Mr. Ahmed, there is a plan.
No, your lordship will kindly see. Since I filed it in January 2025, what they have done is this, to take a revenge on me for filing this writ petition, they, my lord, stopped my ingress and outgress. And your lordship will kindly see the plain. What I have prayed for, a permanent injunction to not to disturb my possession. In that background, my lord, when Order 39, Rule 1 and 2 application was made, so that my possession is not disturbed, when a status quo order was passed. And it is when they contested the status quo.
I'm not getting into your civil suit at all.
I'm not referring to it also. Because from the civil suit they had filed for the first time that they have got a sanction. Now the sanction, my lord, your lordship will kindly see, it's sanctioned under 3-2E.
Whatever it is, you challenge the sanction.
Yes, I'm challenging that. Now it has become a part of that.
Kindly see the order.
Where is your prayer for challenging the sanction?
No, my lord, because
Mr. Ahmed.
I understand. But only thing is this, my lord, even assuming, my lord, it is a sanction plan.
Mr. Ahmed, not assuming. They have a sanction plan. I'm not assuming it. They have a sanction. Yes,
my lord, your lordship will kindly see the sanction. Let them file the sanction plan.
Why should they file a sanction plan, Mr. Ahmed? If you are aggrieved by the sanction plan, you challenge the sanction plan. If you feel that the sanction plan has been given to them without complying with the due process of law, then you challenge it.
No, may just.
Who's stopping you from challenging?
I'll just take a minute of your lordship.
Kindly see the order of the civil court, my lord. Kindly see
just a minute.
It's all about construction.
No. Civil, that part, my lord, I have taken care of. They're saying like in the city of Calcutta, if you're not allowed to construct floors, where will the citizens go?
Apart from that, It was done after due survey by the engineer commissioner. A report was filed.
Yes, Manoj. I have taken this point here.
Taking the point will not help you, Mr. Ahmed.
No, I have taken a point, Manoj. Your Lordship will kindly come to paragraph 18, page 8. May I just read it? The petitioner states that the complaint lodged with the respondent number 5 disclosed cognizable offense of criminal intimidation, threat, and so on. I'm not on that. And as a consequence thereof, the private respondents commenced the proceeding with the partially demolition of washroom, hurriedly proceeding with the construction of the support pillar for construction of by falsely representing grant of permission for construction under Rule 3(2)(e) of
Mr.
CMC.
Ahmed, I think you know law much better.
No.
Why are you asking me to
No.
unnecessarily comment on it?
No. Your Lordship will kindly see that rule.
Mr. Ahmed, you have to challenge it, Mr. Ahmed.
Yes, yes.
I totally understand that in one of your grounds you may have taken this plea, but you know exactly. If you have not asked for it, you will not get it.
No. Because your Lordship will kindly say
Kindly
that.
see the prayer in their injunction application.
I am not concerned about the suit.
No, may I, one more minute, Manoj.
All right, we will have it on. There is no urgency here. Why have you made it unnecessarily urgent? We'll have it after vacation. There is no urgency here. At the request of the parties, let this matter be listed after vacation.
When a construction, if made by, will abide by the result.
Nothing. 27th of June.
Grateful.
There's nothing, Mr. Ahmed. Nothing.
What we are doing, my lord, is.
I'm not even dismissing it. I should dismiss it.
This is happening, my lord, 3(2)(e).
Mr. Ahmed, you challenge it. Who's stopping you?
I will do that, my lord, because I could not do it because I was, but it has come to my hand after
So
the
this
suit
you
was
should
filed.
withdraw and challenge it separately.
May I withdraw it then, my lord?
Learned counsel for the petitioner.
And withdraw it with leave to.
Oh, you have learned counsel for the petitioner seeks
Your
to
Lordship will
withdraw.
kindly do this, my lord. Let your Lordship will record his submission that sanction plan they were constructing as per the
I'm
construction.
not recording anything. Learned counsel for the petitioner
is
seeks to
recorded in
withdraw
the
the present writ
civil
petition. The
order.
same is dismissed as withdrawn with liberty to the petitioner to file appropriate proceedings in accordance with law.
Grateful.
Grateful.
I appear for the petitioner, my lord. So this matter, my lord, is a classic example of, my lord, high-handedness of the municipal authorities and how, my lord, they become puppet at the hands of the, my lord, promoters. What happened here, my lord, the petitioner is a 90-year-old person, my lord, lodged a complaint against the, my lord, adjoining premises. A multi-storied building without, my lord, leaving any space in the premises. I filed the writ petition. Demolition order was directed to be implemented. They preferred appeal before the, my lord, division bench. Division bench directed demolish and also consider whether the plan is illegal. That proceeding went to the municipality, nothing has been done till date. What happens, my lord? Municipality slaps a notice upon me saying that your building is illegal. I have received some complaint, attend the hearing. I immediately write a letter that no copy of the complaint is served upon me, kindly supply me a copy. I don't understand what is the complaint because my building is more than 30 years old. I have a valid plan for the entire building. It is access to the municipality. No copy supplied. On the date of hearing, my lawyer goes with a vakalatnama. Lawyer said, you get out, tell that man to come. This is the high-handedness, my lord. This is not very bad shape, my lord. The lawyer was not allowed, instead, in spite of having a vakalatnama, said you go out. He was basically thrown out of the room, said your client has filed writ petition, let him come and attend the hearing personally. This happened, my lord. On 2 days, the lawyer went, he was not allowed. I have challenged, my lord, the proceeding. This notice, my lord, kindly see, my lord. I'll just show the notice.
My lord, may I submit, my lord?
Yes.
My lord, I am appearing for the municipality, my lord.
Yes.
My lord, on the date of hearing, my lord.
Take his number, name and number for Uttarpara. Manoj, I'll give you a number, huh?
ওইটার হয়ে দাঁড়িয়েছিল নাম কি নামটা
আমি
Permitted to mention, madam.
আগের ম্যাটারটা কি
It is same matter.
I'm sorry.
My lord, we are permitted to add a
Hey,
party.
कौन है? आयो दीपक और मुखर्जी,
নিখিল কুমার গুপ্তা মালা নিখিল কুমার গুপ্তা মালা
निखिल कुमार गुप्ता, टेक डाउन इज
My,
उनका भी डाल लो.
নিখিল কুমার গুপ্তা
my lord, may I admitted to as a party, add-on party, because I am the developer and residential of all the flat owners.
This has got nothing to do with you.
Regarding my building.
It has got nothing to do with you. Is he seeking any relief against you?
My lord, this is a,
Is he seeking any relief against you?
my lord, this is a related to this order, kindly see this order.
This is related to a notice which he has received.
No, sir, notice not received, but I am related to this matter because I am getting suffered before his deliberate non-attendance, deliberately not attending the meeting, which has been.
You file your separate writ petition if you are suffering. Yes, Mr. Banerjee.
May I just show not 3 documents? First is the notice. Oh, before that, kindly see the division bench order, which I obtained, my lord. That is not at page 42. Page 42 is the division bench order. In my case, but the division bench dismissed the appeals and directed demolition. This is regarding, my lord, adjoining premises, which my learned friend is referring to. After this, kindly see the notice that I get at page 46.
Yes.
Kindly come to page 46, annexure P7, my lord, the notice to my client. In connection with the complaint against the construction of your building at municipal holding number 58 New Station Road, you are requested to please make it convenient to meet the undersigned for a hearing in the matter with all relevant documents in support of your land and construction. Page 46. I immediately reply, my lord. Next page, 47. Saying that I have received your letter, but I don't understand because my building is an old building. Kindly give me the nature of the complaint. Requested for a copy. Necessary documents and the complaint. Page 47. Nothing supplied. Page 48 is not my lawyer's vakalatnama with which he appeared before the municipality. Page 48. 2 matters were taken together. One is not the other complaint, and one is some complaint against me, which copy has not been supplied to me. So my lawyer appears not allowed. Page 52 is the letter of the lawyer. Mr. Shumon Banerjee, he appeared, my lord. He was not allowed to submit. He was asked to go out. Page 52 is the letter the lawyer gave immediately on that date.
না মেইলও আছে
And also email
ইমেল ওই ডেটেরই
to the municipality.
ওই ডেটে এরপরে আমার
After this note, I filed the writ petition, served the copy. Another notice has been given to me. Last chance is given to you. You appear. That is not part of the writ petition. Recently, I have got me. That is why I mentioned the matter. They are possibly minded to pass an order against my building, but they are not allowing the lawyer to go in. Now they have fixed 24th as the next hearing. Without a lawyer, the 90-year-old man has to go.
Give me yes.
My lord, when the date of hearing took place, my lord, the petitioner sent the lawyer, my lord, and the lawyer has come up with a blank vakalatnama, with no instruction, nothing, my lord. And my lord, there he tried to fill up without signature.
All right. You are a lawyer. How long you have been practicing? So you know what you are saying. All right. Now you will give a hearing. Don't make this submission.
We have given ample opportunity, my lord. 2 hearing was given on that day. The
Give one more hearing.
was absent, my lord.
Give hearing.
24th, my lord, there is again one hearing, my lord, and the last time for the petitioner and the private respondent board.
Give him a hearing on 24th.
Already given, my lord. 24th is the date, my lord. 24th May.
24th May, you'll give a hearing. Give a hearing on 24th May. They will allow you.
Lawyer will appear, but they have to supply a copy of the complaint. No inspection, nothing has been conducted by them. Let them conduct an inspection. Kindly don't dispose it off, because what they will do.
No, no, sir, I will dispose it off. Against a notice, not even maintainable. Nothing is maintainable against a notice.
Kindly consider the aspect of natural justice.
Sir,
Because the law.
Mr. Banerjee, is just a notice. There is no final order which has been passed. I will give you the right to be represented. That's it. Nothing more. No
Kindly give me
direction.
that right, and a copy of the complaint has to be supplied, because I asked for the copy. Nothing supplied to me. Who has complained? What is the extent they are saying is the deviation? Let them not
Take down.
provide the particulars, because I
The
have a valid
petitioner has
plan.
preferred the present petition. This is item 80. The petition
And not, let them not misbehave with the lawyer.
is
The lawyer
agreed
is
by the
present here,
show
my lord.
cause that I can't.
Chairman lord has misbehaved with him, my lord.
Just, my lord,
He is
assuming
present.
everything,
No,
my
this is
lord,
happening, my lord. They have become too powerful, my lord. Let there be camera, CCTV, my lord. Let there be.
they are seeing everything.
Anyway,
The lawyer is present personally. Don't
The
make
petition-
aspersion against your learned friend. You are also a lawyer. This might happen to you also.
That's why
He is present
all
personally.
right, all right.
Don't say all these things.
Petitioner is agreed by the show cause
Taking a plea for the
notice
client and
dated 24/2/2025 issued by the respondent municipality alleging unauthorized construction at premises at holding number 58 New Station Road, Ward number 7, Uttarpara, Kotrong Municipality District, Hooghly. Full stop. It is a case of the petitioner that he is the absolute owner and resident of holding number 58 New Station Road, Ward number 7, Uttarpara, Kotrong Municipality District, Hooghly. Full stop. His next door neighbor at premises number 236, New Station Road, PS, Uttarpara, was carrying out unauthorized construction without any sanctioned building plan. Full stop. Further, no mandatory space was left on the sites, thereby causing
he had a plan but deviated.
Sorry?
He had a plan, but there were deviations, huge deviations. So far the adjoining premises.
All right, the new change it. He was carrying unauthorized construction in deviation of the said sanction plan. All right. At the instance of the petitioner, the respondent municipality passed a demolition order dated 8/9/2016. Full stop. For the implementation of the said order, the petitioner approached this court, and finally an order dated 21/2025 was passed in MAT number 1757 of 2023. The Honorable Division Bench directed the respondent municipality to implement the demolition order dated 8/9/89, right?
Demolition order, division bench order টা
Division is 20th January.
না ওখানে ডেটটা লেখা আছে কবেকার
8/9/2016. 8/9/2016 as per the direction of the learned single judge, and also directed to initiate fresh proceedings to consider the aspect of illegal sanction of the building plan. Full stop. The respondent municipality was directed to pass a speaking order after hearing all the concerned parties. Full stop. The respondent municipality issued notice for conducting the hearing for examining the aspect of illegal sanction of the building plan. Full stop. The petitioner received a notice dated 24/2/2025 qua his premises alleging unauthorized construction, which he feels is because he has lodged a complaint against his neighbor. It is the submission of the petitioner that he has constructed the said building in accordance with the sanction plan, and the same is 30 years old. He has been paying the property tax on the said building for the past 30 years. The petitioner, being an octogenarian, has engaged his lawyer to attend the proceedings before the municipality. Full stop. but the concerned officials refused to entertain petitioner's lawyer and insisted upon petitioner's personal appearance. Full stop. Being a senior citizen, counsel for the petitioner states that it will be difficult for the petitioner to attend the hearing personally. Full stop. Learned counsel for the respondent municipality submits that the next date of hearing is on 24th of May 2025. Full stop. He assures this court that the petitioner's lawyer will be allowed to represent the petitioner at the time of such hearing, and that the officers concerned will not insist upon the personal appearance of the petitioner since he is a senior citizen. Full stop. In view of such submission, the present writ petition is disposed of with the direction that the municipality shall allow the lawyer of the petition, the nominated lawyer of the petitioner, to represent the petitioner on 24th of May 2025 before the Uttapara Kotrung municipality. Full stop. With the above direction, the present writ petition is.
Copy of the complaint will be supplied. Otherwise, I will not be able to. The lawyer will not be able to.
ऊपर लिख लेना. The said notice, the said notice mentions that the said notice states that a complaint has been filed, and due to such complaint, the municipality had issued the show cause notice to the petitioner. Full stop. A copy of the said complaint shall also be handed over to the petitioner to ascertain the nature of unauthorized and illegal construction which has compelled the municipality to issue the show cause notice.
Deeply obliged. We shall go and take all points before them. Much obliged.
Affidavit of service taken on record.
My lord, I beg to appear on behalf of the petitioner, my lord.
Appearing for the municipality, madam.
The matter was appeared.
Yes, yes, yes. Where is the report?
On behalf of the
Report. Reporter একটা copy দেবেন?
You are appearing for the state or what? Municipality?
My lord, I am appearing for the.
Yes, yes, madam, what happened?
My lord, your lordship, kindly consider, my lord. The revised, my lord, sanction plan has been approved for G+3, my lord, 4-storied building. And your lordship, kindly see the impugned order, my lord.
Yes.
My lord, a complaint has been made, and on the basis of that complaint, the municipality caused an inspection. And my lord, on the basis of the inspection report, my lord, the order has been passed.
But kindly,
My lord, I'm,
Just a minute.
my lord.
Yes.
I'm reading the relevant portion, my lord.
Page 42, huh?
Page 45.
45.
The impugned order, my lord.
Yes.
No, impugned order, it took page 46.
Yes, yes.
In continuation of the last one.
Kindly see the order 28th February 2025.
Yes.
That I'm reading the 4th paragraph. The petitioner and other respondents are found present, but Shankar Prasad, one of the respondents, is found absent in spite of service notice. The following are reflected from the inspection report dated 29/11/2024. Building plan being number 237 dated 30th June 2001 has been sanctioned for G+3-storied building at holding number such and such. Number 2, 2.8 meter height and area measuring about 42.67 square meter RCC structure, slab, beam and column are being made over the 3rd floor roof. These construction are beyond sanctioned building plan. So, my lord, the building plan was sanctioned for G+3, my lord.
And the additional floor, that is 42.67 square meter, that has been made, my lord, without sanction plan. So demolition order has been passed, my lord. My lord, the petitioner was given 30 days time. That has been over. So, my lord, the municipality will.
Yes, so what is the illegality, sir?
I kindly come to the page of 46, my lord.
Yes.
My first submission, my lord, that this order of demolition is not binding upon the petitioner, my lord, just because the order of demolition has passed for a premises situated in ward number 10, my lord. My premises is situated in ward number 9, my lord.
It doesn't matter. Yes.
My lord, even in the said proceeding, my lord, the concerned ward commissioner was not present, my lord. So, my lord, this order passed by the chairman only, my lord, cannot be sustainable in the eye of law that has been held by the division bench of this honorable court, my lord, in a where the section 218 has been elaborately interpreted, my lord, and the order of the chairman has been set aside, my lord. If the order is not passed in consent of the board of consular, my lord, kindly come to the inner page 3 of the order passed by the division bench, my lord.
Yes, show me from the order.
Which order?
The impugn order.
My lord, kindly come to the page 46, my lord. Or first come to the page 45, my lord. On 25th November 2024, Shri Surujit Rai Chaudhary, Councillor of Ward 10, filed a complaint before this office against Shri Shankar Prasad regarding illegal construction at holding number so and so, Ward number 10.
Yes.
The Councillor of Ward number 10 have initiated a proceeding under the conception that the premises in question is situated in under the Ward number 10, my lord. Now, my lord, kindly come to the page of 46, my lord. The copy forward to Shri Surujit Rai Chaudhary, Councillor of the Ward number 10. My councillor is, my lord, Rita Rai Chaudhary, who is the respondent number 9 in the writ petition, my lord. No copy has been served upon the Rita Rai Chaudhary, my lord. She had not been the part of the proceeding before the Board of Consular, my lord. Even she was not present before in the Board of Consular, my lord. The order passes without the consent of the Rita Rai Chaudhary, the concerned Ward Consular of the Ward number 9, my lord. So the order passes without consent of the Ward number 9, my lord. Councillor of the Ward number 9, my lord. So, in the light of the division bench order, my lord, the order passed by the chairman is
This
not
is not-
sustainable in the eye of law, my lord.
Not by the chairman, it's not it's
Not
not.
by the chairman, it's by the board of.
Not, it's a board of councillors pass.
Yes, yes.
But he's from the year he's saying everything.
I know.
One floor has been constructed without plan.
Now, my lord, regarding the legality of the construction, my lord,
237.
my lord can see from the page number 36 onward, there is nowhere the name of Rita Rai Chaudhary, the concerned Ward Councillor of the Ward number 9. Yes, required. The premises is situated under the Ward number 9.
What provision of law? Tell me. The Deepak Maji's
Kindly gone through a minute report which was submitted by the officer.
The definition of
Your report is of no use to me.
my lord के बोलते थे
the section 14, the definition of word of concealer, my lord.
कौन आदि
All right.
Regarding,
Nothing is here, sir. Sorry.
regarding legality of the construction, my lord, I have obtained sanction building plan in 1997, my lord, for the 3-storage building, my lord. There was completion certificate has also been issued, my lord. Completion certificate has also been issued.
Not talking about third floor, sir. They are talking about the floor above third floor.
My lord, kindly come to the page number 30, the sanction building plan. That has been issued for 4-storage building, my lord. Page number 30.
Ground plus 3, sir. You are constructing above the third floor. What is wrong with you?
Then kindly come to the page number 34, my lord.
Yes.
The ARC copy issued by the concerned municipality, my lord. The recorded
Municipality,
property,
you can put it for 10 floors also. Doesn't matter.
recorded property, my lord. 4th floor, the municipal tax is being paid against the construction, my lord. Page number 34.
That doesn't right to make.
Just take down, Saurabh.
My lord, only the Mumty room is constructed over the 3rd floor.
Demolish it.
Nothing else, my lord.
All right. Very good. The
And
petitioner
no
has-
inspection report has been served
All right,
upon
sir.
me.
Have you made your submission now?
My lord, no inspection report has been served upon me, the writ petition, my lord. Where from the measurement regarding the 46.2.7 has come, no report has been served upon me, my lord.
Made your submission?
My
Anything else?
No, my lord. The report will be served, my lord. I will file objection if required, my lord.
All right. Done? Take down. The petitioner has preferred the present writ petition challenging the order dated 28/2/2025 passed by the chairman, South Dum Municipality. Passed by the Board of Councillors, South Dum Municipality, whereby the petitioner was directed to demolish the unauthorized construction measuring 42.67 square meter existing on the 3rd floor of the premises situated at holding number 240 New, 390 Old Dum, Kosipur Road, Ward number 10. This is Ward number 10, right?
Yes, my lord.
No, my lord. Ward number 9, my lord. This is ward number 9, my lord. I can show you from the property tax, my lord. Kindly see, my lord.
Ward number. Sir, don't interfere.
Hey, look, ward number 9. Ward number 9.
Please.
এটা 22/11/2024 এ প্রপার্টি ট্যাক্স। ওখানে পুরো প্রসিডিংটা ওয়ার্ড নাম্বার 10 এ अगेंस्ट আছে।
10 এর নাম্বার না ভুল হয়েছে।
Dum so and so. Kosipur Road, Calcutta. Leave the word. The petitioner contends that by virtue of a development agreement executed in the year, can you please keep quiet?
My lord, kindly.
Can you keep quiet?
I am assisting the court, my lord.
I've heard enough. I asked you, you make your submissions.
My lord, I have.
Take your seat. Sit down.
I'm sorry.
Not even a word from your mouth. The petitioner contends that by virtue of a development agreement executed in the year 1996, Miss Amulya Ranjan, the erstwhile owner of the said premises, became the entitled of the said premises, the petitioner became entitled to the ownership of a portion of the building to be constructed thereof. Full stop. The said landowner also executed a registered power of attorney in favor of the petitioner. Yes, based on these documents, the petitioner obtained sanction for construction of a three-storied building on 3/9/1997. Full stop. Subsequently, in the year 2001, the building plan was revised and sanction was granted for construction of ground plus 3 floors. In 2024, the petitioner, full stop. On 26/11/2024, the petitioner received a notice from the respondent municipality stating that an inquiry has been initiated pursuant to a complaint alleging unauthorized construction. Full stop. After providing an opportunity of hearing to the petitioner, the Board of Councillor passed the impugned self-demolition notice dated 28/2/2025. Learned counsel for the petitioner submits that the impugned order is vitiated as no copy of inspection report was furnished to the petitioner. It is further submitted that the councillor of Ward number 9, within which jurisdiction the subject premises fall, was not present during the proceeding. Full stop. Learned counsel for the petitioner further contends that the present order has not been passed by the Board of Councillors and is in violation of Section 218 of the West Bengal Municipal. What is this? Which act is this? West Bengal Municipal Act 1993. Full stop. Any other submission? That's all? Is your submission? All right. Learned counsel further states that there is no unauthorized construction in the premises and thus the impugned order is liable to be set aside. Full stop. This court has heard the argument advanced by the counsel for the parties and has perused the materials on record. From the record, it is evident that upon noticing the alleged unauthorized construction, the respondent municipality conducted a joint inspection after issuing due notice to the petitioner. Full stop. The petitioner was also afforded an opportunity of hearing. Full stop. A perusal of the impugned order reveals that the learned advocate appearing for the petitioner admitted the existence of unauthorized construction to the extent of 42.67 square meters on the 4th floor. Full stop. In view of the above, this court is of the considered opinion that the order passed by the Board of Councillors suffers from no legal infirmity or procedural irregularity warranting interference. Full stop. Consequently, this court declines to interfere to exercise its discretionary jurisdiction under Article 226 of the Constitution of India. Accordingly, the present writ petition is dismissed. Next.
Only the inspection report.
Sir, I have recorded everything which you have said.
If directed, my lord, to supply.
Anything which I have not recorded, which you have said.
My lord, but
all right. Then I have given my finding. Now it is for you to challenge it in appeal.
But tomorrow is the date for demolition.
So get it demolished. Seek compensation.
Date for my lord.
You should be aggrieved if the court is not recording your submission. I have dealt with all your submissions. Thank you very much.
Measurement of the 42 is coming.
Thank
my
you very
lord.
much, sir. Thank you. Next.
Grateful, my lord.
My lord, I am appearing for the petitioners.
Yes,
my lord. Yes, my lord. Out of 22, my lord, councillor, my lord, 12 councillors, including vice chairman, came before your lordship. And straightway come to my lord lists of dates, my lord, Roman 4 of this writ petition.
Where is your list of dates? List of dates.
Yes. On 28th February 25, my lord, notice issued to the petitioners.
Wait a minute, where, list of dates, 28th February, yes.
Yes,
Notice issued to
my
the
lord,
petitioner.
notice regarding the presentation of revised budget for
Yes.
the year of 2024, that is also violation of municipal law section, and the budget estimated 25-26. My lord, meeting was held on 7th March 2025. My lord, there is all councillor was present, and my lord, they raised objection.
Yes.
That's why budget could not pass. And my lord, written intimation, my lord, subsequently on 8th March 2025, there is a written intimation by the head clerk to the all councillor regarding the whereabouts the resolution book or meeting book. My lord, that intimation by the head clerk, that my lord, resolution book was taken by the chairman. My lord, it was intimated by the head clerk. On 12/3/2025, again notice was issued, follow-up meeting schedule on 24th March 2025. Meeting will be held on 2020. It is again violation, my lord, budget will be passed within 15 March of the particular year. That's, my lord, on 12 March, that meeting will be held on 24th March 2025. Again, my lord, regarding, my lord, on 93, my lord, 19 March 25, petitioner sent a written communication regarding the unlawful conduct of the chairperson. My lord, they lodged complaint before the bodies. On 15 March 2025, another communication sent to the petitioner regarding the illegal conduct of the chairperson. Thereafter, petitioner email objected the budget presentation of 7/3/25. My lord, subsequently came to know that budget has already been passed on 7th March 2025. Though, my lord, it's passed my only, my lord, type copy. No signature. My lord, may I, my lord, submit? Kindly call for a report so far this allegation is concerned to the, my lord, respondent number 2 and, my lord, SDO or DM.
And how much has been disbursed?
And my lord, in the meantime, without budget, they pass the entire bill amount, my lord, in the, my lord, in his favorite, my lord, person. It's totally violation, my lord, section 84, 82, 82, 1, 2, and, my lord, 4, subsection 4. Hey, it একটু দিয়ে দাও তো। No, sir.
So you are saying despite the objection raised by all of you, she has passed the budget?
Yes, ma'am.
What are you seeking?
I'm pair. পেয়ারটা দেখাও ওটা আমার কোথায় ছিল
কাগজগুলো দাও
হলো পেয়ার বি
Yes. What section were you showing? What were you showing, Mr. Mandal?
Yes, my lord, pair B.
No, what were you showing? The
82.
82.
subsection 1 and 2, that should be passed in the 10th day of March every year. Notice issues, meeting will be held on 24th March. And subsequently 2, the budget estimated ensuing year shall be adopted after discussion by the board councillor within 2 weeks from the presentation. And my lord, section 4, the revised budget, my lord, revised subsection 4, a revised budget for the current year shall be framed in the prescribed form during the middle year and presented before the board of council adoption after the first day of October. My lord, notice has been issued so far, my lord. Back year is concerned 24-25. That is also violation, my lord. 80, not current year, 82 and 82 subsection 4. If any revised plan path, my lord, should be before October the particular year.
Yes.
My lord, for the municipality, my lord. First of all, my lord, on 7th of March, my lord, every councillor were present. And on the basis of that, my lord, and budget.
There is a record.
My lord, budget is not required to be passed. It has to be approved. My lord, everything is there. That resolution is at page 51. Now, my lord, after this, what has happened, my lord, today, yes, this is the resolution, my lord, everybody has signed. And most interesting thing is that everybody has received their remuneration on that date. So presence of the councillors will be evident, my lord, that they have received it.
Yes.
It doesn't pass.
Meeting
Now, my lord, there is a serious, my lord, pressure, my lord, in respect to some councillors. What is the quantum? There is nothing. They are only objecting that how this budget has been passed. Now, my lord, today, my lord, I have an instruction. Yes.
You file your report. The petitioners who are councillors of Krishnanagar municipality, Nadia,
An audit report I am carrying with me for lordship.
File it. Krishnanagar municipality, petitioner who are councillors of Krishnanagar municipality, Nadia, preferred the present writ petition seeking a direction against respondents for taking action against direction against respondents for taking action against respondent number 5, chair bracket में डाल देना chairman of the said municipality bracket close, and also for conducting independent impartial inquiry into the conduct of respondent number 5. Full stop. You are seeking direction against whom? Respondent. Which respondent shall do it?
My lord, reports about respondent number 2 and my lord SDO. Subdivision.
One intervention, my lord, if you lordship allows me.
Respondent number 2 and 4.
So I'll seeking direction against respondent number 5, right?
5.
Well, DM can file
seeking direction to respondent number 2 and 4 for
Okay.
taking action against respondent number 5. Full stop. It is the case of the petitioner that despite the respondent number is the case of the petitioner that the respondent number 5 with malified intention has manipulated the minutes book, the minutes book of the meeting of the resolution dated 7th
March
2025 and has wrongly portrayed the facts before the public at large. Full stop. Even though revised budget for the year 2025, the budget has been approved.
The budget is already passed, my lord. My lordship will kindly.
It is further. It is a contention.
There is a.
Learned counsel, the petitioner further contends that the budget for the year 2025 was not approved by the councillors, but the same has been illegally approved by the chairman. Respondent number 5. Full stop. Further, petitioner alleges that there has been embezzlement of funds by respondent number 5. Full stop. Learned counsel for the respondent.
Number 5, my lord.
Number 5. You have number 5.
5 to yes. The municipality, my lord, 6. Sorry, and for the 6.
Learned counsel for the respondent number
5 to 10, Mala, 5 to 10. Sorry.
5 to 10 appears and states, yes.
Yes. Now my contention is that on 7th March, everybody was present, and in 82, there is no provision for passing of the budget. It's required to be adopted.
States that the councillors were present at the meeting held on 7th of March 2025. and
One indulgence.
They had approved the said resolution.
No, one later, madam.
He seeks and is granted 4 weeks time to file his affidavit in opposition. Reply to the same, if any, within 2 weeks thereafter. Full stop. Let this matter be listed after 8 weeks.
Within 2 weeks.
Within?
2 weeks there.
No, I'm giving them. When do you want, Mr. Mandal?
As you.
I'm giving after 6 weeks.
As you.
So 4 weeks, 2 weeks, after 7 weeks. After 7 weeks, let the matter be listed after 7.
Only one indulgence, my lord, because in the meantime, yesterday, some development has happened. If your lordship kindly record.
Place it on record.
Their grievance has been already redressed and it has been already sent to the local bodies.
Why
They want, to be very candid with your lordship, all are in the same platform. Somebody wants the power. Somebody wants the power, and my learned senior friend knows much better
Kindly
than
call
what
for
happens.
an inquiry report from the SP of the particular, everything. Everything will be solved.
My learned senior friend is what he is submitting. He knows better than us.
Present before your lordships out of 21, including the vice chairman. How they came before your lordship?
Vice chairman,
Let them file the report.
Kindly call for a report.
I've asked them to file their affidavit. You are appearing for? You file your report. Who all have to file, Mr. Mandal? 5 to 11 is filing it.
2 and 4.
Who's appearing for 2 and 4? You file your report. Respondent 2 and 4 shall also file a report by way of an affidavit within a period of 4 weeks. I'm keeping it after within a period of 4 weeks, exception to the same, if any, within 1 week thereafter, list after 7 weeks. File your report. Who do you appear for?
I am led by Mr. Chakrabarty.
Careful, Mala.
21 were appear for the petitioner, my lord. In the matter 39, my lord. Yesterday mentioned that.
Both the matters were directed to
be taken up together.
So far,
That,
so far,
408.
No, my lord. My lord, we have challenged the self-demolition notice issued by the Howrah Municipal Corporation, my lord.
Yes.
My lord, on the last occasion, my lord was pleased to direct the Howrah Municipal Corporation to bring the original, my lord, the demolition order, my lord. Since no demolition order was communicated to the petitioner, no statement of reasons was communicated.
I have taken instruction. This notice was itself given, but no demolition order was directly communicated. So, my lord, if your lordship so directs, I will pass a demolition order, or otherwise, my lord, I will give them a hearing and pass the order.
The hearing was complete. Thereafter, but no demolition order, my lord. But section 170. But who is he? But the Howrah Municipal Corporation is the appropriate authority, my lord. But the 177 one says, my lord, the order of demolition.
I have got from them the order, but that order has not been passed. Only this order, demolition order has been passed.
Demolition order has not been passed.
Required, my lord. Actually, I have asked them. It was required, a reason order required to be passed. Actually, they do not consult me. This is the problem in
No, but he has challenged the demolition order of.
Yes, they have given a self-demolition order.
Self-demolition notice, my lord.
Reason order was not given.
After hearing,
a reason order ought to have been given. I just came from them. I got from the news that this order has been passed, but no reason order was passed.
What
Your
is
lordship
this,
got
Mr.
for me
Banerjee?
the demolition order or reason order. That has not been passed.
No, what do you mean by?
After hearing, my lord, we have to notify the minutes. What they have submitted, what they have submitted. Thereafter, the reason order passed. Thereafter, the self-demolition order required to be passed. This is the normal procedure. They have straightway made the self-demolition notice because, but they thought that this will do.
Then you withdraw this.
I can.
Similar order.
Learned
my
counsel
lord,
for
my
the
order, my lord.
respondent
Lordship, I don't, they are
states
similar
that
order
the,
passed by my lordship.
what is this?
কি কপি দেন দিন একটা কপি
কপি দিতে পারবে না, কপি দিয়েছিল দেননি।
না না যে অ্যাড্রেস আপনি রিটে ফাইল করেছেন সেই অ্যাড্রেস
হ্যাঁ,
একটা কপি দেবেন
একটা দিন।
সিমিলার অর্ডার কি বলতে?
আমি দিচ্ছি, আপনি সিগনেচার দিন।
এইটাতে?
হ্যাঁ, ঠিক ঠিক ওনাকে দিন। ওনাকে দিন।
না না উনি তো কপি পেয়েছেন।
আমি
Mr. Banerjee, you are trying to save them.
No,
You are trying to
that
save
is
them.
not
Mr.
that.
Banerjee, if the entire construction is unauthorized,
Entire G+1 entire
then
construction authorized.
what order you're going to pass?
After hearing, it requires that a reasoned order is required to be passed. That I know. But so far as self-demolition notice matter may cease, if your lordship so says, I should be fair in every matter. Now, my lord, I think this is a G+1 construction, and my lord, if goes to the self-demolition notice, it is at page 53, my lord. Page 53. You that to demolish the unauthorized construction from G+1 structure within 7 days from the date of receipt. That is the actual the law. 7 to 15 days time is required to be given as per law. But so far as the reasoned order, as we have given them a hearing, that order has not been passed because your lordship asked me to give a demolition to communicate a demolition order. That I have not found from them. Now I can proceed on basis of this order also because they have. If they do not self-demolish, I will demolish it by informing the police. That we can do.
No, but you are blowing hot and cold at the same time. You are saying that you have not given them a hearing, so you want to give them
I
a
have
hearing.
given a hearing.
hearing also.
But
Hearing
no,
given.
my lord, the no,
But
my lord,
reasoned order has not.
demolition order was communicated, my lord.
Hearing
As required under section
But reasoned order
177(1).
has not been passed. I have given them a hearing. That is all right.
So you pass a reason order.
I will pass it. That is I am saying. And my lord may keep this in abeyance for 7 days or 10 days. I will give the reasoned order.
As you wish.
Automatically, I will pass the
Take
reasoned
down.
order.
Learned counsel for the respondent, Havra Municipal Corporation, states that though a hearing was granted, no reasoned speaking order has been passed. He seeks 2 weeks time to pass a reasoned speaking order. Full stop. Let this matter be listed after 4 weeks.
I will pass the reasoned order. Thereafter, my lord will pass the order.
In the meantime, the self-demolition notice dated 2/5/2025 shall be kept in abeyance till the respondent passes a
And communicate them.
Yes.
and
I will communicate it before the lordships itself.
Both party, my lord.
Because again, I will find out them and they find out everyone.
a report shall be filed within a period of 2 weeks.
2 weeks.
Let this matter be listed after 4 weeks.
Grateful. Grateful. Well, it covers both the petitions, 21 and 39.
39.
21 is this one.
39.
What is 39?
39, this petition, I am filed a petition for demolition. After hearing order was passed, then they filed this petition.
But
39 shall be listed along.
and
with
my lord, item number 234, my lord. My lord, 234, my lord, I have also challenged that.
39. Just
39.
And also, my lord,
shall be listed along.
and also, my lord, 234, my lord, I have challenged the unauthorized construction at the instance of private respondent.
What
That is not.
Oh, yeah. Another
It has got nothing to do with this.
234 maybe.
234.
No, nothing.
About 234 K. It হয়ে গেল আবার 234.
21
এই নিন, দাদা, এটা গেট 234 কি ফাইল করেছেন? ওই আমার পাইনি তো 234 এটাও তো করেনি পাই দেন আমাকে রিসিভ করে পাইনি।
Wait, please, Your Lordship.
Yes.
My lord, this is the matter, my lord, where my lord, my bills.
Yes.
My lord, I received purchase orders, my lord, which I annexed
Yes.
at page 22 onwards. My lord, this is my affidavit of service. Then, my lord, the bills were raised, which are, my lord, 29 onwards.
Page.
page 22 onwards are the purchase orders. And I am the distributor of Tablet India and I distribute medicines
Yes, yes, sir.
upon government contracts, my lord.
Yes.
So KMC gave purchase orders to me,
Yes.
which are 22 onwards. Then I raised bills after supply, which are 29 onwards. Then, my lord, Tablet India's letter, my lord, where, my lord, the rates, my lord, were that the rates were genuine, my lord. That was, my lord, given, my lord, in page 82, where Tablet India, my lord, requested release of payment. My lord, sees page 85.
Yes.
Then, my lord, there was an.
That's why I'm interpreting my lord. Understand, my lord. Your lordship heard this matter.
I heard this matter. I know. I know this matter. Mr.
My lord.
Ghosh, the only difficulty is when you have taken something, you have consumed the tablets.
My
The
lord.
only ground on which you didn't release the payment was a pending inquiry. You tell me the status of the pending inquiry.
But that's so far as that is concerned, my lord. That was, my lord, looked into by the honorable single bench.
That's all right.
In the earlier writ petition.
Show
And
me
my
the-
lord, and
Yes,
that, my
yes.
lord, so far as that is concerned, my lord, that you can see when the court said, my lord, on that date,
Yes.
that it is, my lord, the time bar. And my lord, disputed question of fact. Well,
All
on
right.
that score, my lord, my Lordship was pleased to, my lord, they are dispose of the.
I
that-
know.
My lord.
I know, Mr. Ghosh.
My lord.
I know what I've done.
My lord.
So I'll pass an order. You intimate what is the status of, you can't take something from somebody and not pay them. It is the first responsibility of the state is to ensure that whatever services they take, they make payment for that.
But that is one aspect of the matter, my lord. With yesterday, I submitted, my lord, if the right team, my lord, accrued in my favor.
Where is that order of justice?
My lord, is at page 97.
97. Before. Yes.
93 and 94.
My lord, the order passed by Honorable Justice Boshak. My lord, that is, my lord, page 93. And the KMC order, my lord, 91. The reasoned order is at page 91.
Your page numbering is so here and there, madam.
Well, may I take out page 91 for your lordship?
91, I have it. I'm seeing Justice Basak's order. Which page is that?
But that is page 93.
Yes. Yes, Mr.
Only I'm submitting to Lordship, my lord, that prior to this, my lord, declaration 651 of 2018.
Yes.
Earlier, there was a declaration 623 of 2017.
Yes.
My lord, whatever the order was passed and the actions taken by in persons to that too, my lord.
Yes.
That was reported to the court. When the court, my lord, took into consideration of the declaration WP number 651/2018. After being informed of all these things, the court took the view that the claim is expressly barred by limitation.
Yes.
And my lord, there is a question of fact, therefore declaration has been dismissed.
Yes.
Therefore, my lord, if that situation was, my lord, prevailing in 2019 when the writ petition was taken up by the honorable single bench, coordinate bench.
Yes.
And that, my lord, observation is on record. On the same issue, my lord, he is, my lord, again reiterating by filing this writ petition, that, my lord, that is to be done. But therefore, I'm submitting, my lord, that investigation part, what is now, my lord, alleging, that was looked into by the honorable single bench. And, my lord, thereafter the person order, he could have, my lord, taken up the matter before the other forum, before the appellate forum. He has accepted that order. But what prompted him to make a second writ petition after this order, my lord, being passed by the court.
You tell me the status of the pending vigilance inquiry on which you are not making the payment. Yes, take down. The petitioner has preferred the present writ petition, being aggrieved by the inaction on part of the respondent in failing to disclose details regarding the pending inquiry initiated by the Vigilance Department. Full stop. The petitioner's outstanding dues have been withheld by the respondent on the ground of said inquiry. Full stop. The case of the petitioner is that he is an authorized distributor of MS Tablets India Limited. Full stop. Pursuant to 7 valid purchase orders issued by respondent number 15, the petitioner supplied medicines and subsequently raised 8 invoices and delivery challans aggregating to rupees 18,86,211 in between 16. What is the date? Between for the for the years 2014-15 and 15-16. Full stop. However, the respondent failed to release the said amount. Full stop. The petitioner had earlier filed writ petition number 623 of 2017, which was disposed of by this court by an order dated 12/1/2018, directing the respondents to consider petitioner's representation. Full stop. In compliance with the aforesaid direction, the respondent issued an order dated 14/7/2018 stating that the non-payment of the petitioner's due was under investigation by the Vigilance Department of Calcutta Municipal Corporation and that payment would remain withheld pending completion of the investigation. Full stop. Agreed by the said order, the petitioner preferred writ petition number 651 of 2018, which was dismissed by this honorable court by order dated 14/1/2019, on the ground of maintainability, inter alia observing that the claim appeared prima facie to be barred by limitation. Full stop. The petitioner has been in constant communication with the respondents, requesting for release of the outstanding dues. Full stop. Petitioner has made various representations to the respondent and has sought updates regarding the status of the pending investigation and has been constantly requesting for release of the outstanding payment. In response, the petitioner received a letter dated 20th/4/2022, stating that the representation has been forwarded to respondent number 15. Full stop. No further communication was received thereafter. Consequently, the petitioner issued a legal notice dated 30th/4/2024, demanding for release of the outstanding payment and requesting for information regarding the pending vigilance inquiry. Full stop. The petitioner, claiming parity with similarly situated parties, filed another writ petition being WPA number 21844 of 2024, which was subsequently withdrawn by order dated 19/4/2025. Full stop. Despite repeated follow-ups and representations, the respondent have failed to disclose the details regarding the pending inquiry pending status of or outcome of the pending inquiry. Full stop. It is deeply concerning that the respondents have failed to release the outstanding dues of the petitioner even after a protracted period of more than 10 years on the ground that purported pending inquiry is still underway. Full stop. The medicines in question were duly supplied in the year 2014-15 and 15-16 and were fully consumed without any objection. Full stop. Despite this, the respondents have withheld the payment solely on the ground of a purported pending vigilance inquiry, details of which has not been disclosed to the petitioner. Full stop. There is no explanation as to how the petitioner's legitimate dues are connected with the said inquiry. Full stop. Despite repeated representations and regular follow-ups, the respondents have neither released the payment nor given any information regarding the pending inquiry proceedings. Full stop. Even otherwise, more than 10 years have elapsed since the withholding of the petitioner's admitted dues. Full stop. The respondent cannot be permitted to indefinitely withhold the payment of the petitioner on the ground of pending inquiry. In the considered view of this court, it is appropriate to direct the respondent to file an affidavit within a period of 2 weeks, clearly disclosing: 1, details of the alleged pending vigilance inquiry; 2, the nexus, if any, between the said inquiry and the petitioner's outstanding dues; 3, the estimated time required to conclude the pending vigilance inquiry. Full stop. List on. When do you want, Mr. When do you want it? 4 weeks? 6 weeks? 4 weeks.
21 days?
4 weeks. File your reply.
4 weeks I will give you opposition.
Yes. 4 weeks. Exception, if any, within 2 weeks thereafter. List after 8 weeks.
Well, only I am submitting to your lordship whatever my lord has been pleased to record.
I have recorded everything.
No, your lordship has been pleased to
If you
record.
have any other objection, I'll record that also.
I'm submitting, my lord, 2 things, my lord.
Yes.
Whatever recording has been made by your lordship to give that directions for filing a petition is not entered in the petition. But I'm respectfully submitting that observation, your lordship record that a tentative, because otherwise, my lord, that because your lordship had already reached.
No, I've only given you 3 pointers on which you have to file your affidavit. You file your affidavit on 3 points.
But I will. But
pending inquiry, when will you finish it? Your nexus with the inquiry and the payment. These 3 points you clarify, then we'll see.
No, but your lordship made the observation. If that observation is taken to be correct, then the filing of the opposition, my lord, may not be, maybe redundant. Absolutely.
This is not what observation I made, Mr.
Your lordship said that it has been supplied, it has been consumed.
There is no. Have you? It's on record. Have you made any objection?
I don't
which
know, my lord.
When
something is said that under investigation, if your lordship has gone by the word that investigation,
to come up with investigation report.
But
This is something on record. I have not stated anything which I want to say. I want to say more. That I want to say, Mr. Ghosh.
I'm having it that there is a contention on record which has obtained.
Report.
Would your lordship be pleased to keep the antiquity question open, my lord, in the petition?
Everything is open. Goes
But your
without
lordship
saying.
recorded the antiquity.
I have even recorded that earlier this writ petition was disposed of for not being maintainable, but I feel it's maintainable. All right. Mr. Ghosh, challenge the order if you're so worried about it. Challenge it. These are my observations. I can be wrong.
No, no,
That's why
a-
we have this
well,
system,
that's
Mr.
what-
Ghosh.
that's the thing, my lord. One
This
can
is the best part
apply.
about our
But at
judicial
the first
system.
stage, my lord, our duty to do our best capability to satisfy the bench, my lord. Whatever the order you also consider, my lord, that I am not right to in my
Whatever appeals
then
to our
accept it.
conscience.
Right, of course, my lord, of course.
We only pass.
Everybody, it is also my duty to
Yeah,
satisfy to my.
correct.
Right.
You have
And
seen Mr. Ghosh, you have seen me.
I follow, my lord. That you
I
say
would only
conscious, my
pass
lord.
an order which appeals to my conscience. I can be right, I can be wrong.
That's true, that's true. Get
Much grateful, my lord.
Yes, Mr. Bandapati.
I appear for the petition.
My lord, I beg to appear on behalf of the state, my lord, in item number 24 and 25.
No, since virus of our rules is under challenge, my lord. Learned Advocate General was served, my lord. Since the virus is under challenge, my lord.
Oh, that
I appear on behalf of the Learned Advocate.
But
My lord, the grievances of the petitioner has already been redressed. It has been
not at 4:15.
the scope of the petition has been reduced.
Not at 4:15.
The scope of the petition.
By 4:15, sir, I don't receive anything.
No, it will be disposed of in minutes. Maybe 5 minutes.
Impugn memo perhaps has been
because
withdrawn.
My lord, it has been reverted to the, my lord, the original position of the earlier.
I had challenged a particular notification dated 16th of November 2022, which restricts, my lord, the scope of operation of work in respect of licensed building surveyors under the municipal corporation. My lord, on various legal grounds, my lord, because the rule has not been followed, statute has not been followed, etc. Government has accepted the stand that we have taken, and they say that we have kept it on hold and we'll take necessary steps under the law. All I say is, don't keep it on hold. You can revive it at any moment. Either withdraw it or the court quashes it. Nothing else. Just
For them to respond.
Yes,
my lord,
they can either withdraw
in the
it.
affidavit in opposition, it has been that the government order dated 16 November 2022 has already been, my lord, reverted to the earlier position. So there is no grievances at present in the petition.
That is not saying, my lord, that we have withdrawn it.
Yes, it has been reverted.
That literally means to is withdrawing it.
It is, if your lordship kindly see the affidavit in opposition, page number 9, I have annexed the memo.
Mr. Bandapati, who you appear for?
Lord, since the virus is under challenge, the Learned
Appear
Advocate
for the
General was
state, but
served.
now the virus is not under challenge.
No,
Interesting.
Page 191 was. That's the impugn order, my lord, that we said that it was not made in the form of a rule. It is a merely executive order.
Challenge to virus at 4:20 is very difficult to
Your lordship need not go into all this now. My lord, they say we have reverted. All I say, my lord, is that
Which page?
191 is the impugn. Impugn notification.
Then, my lord, since it is already reverted back, kindly keeps it as the first matter after reopening.
I won't be here, Mr. Bandapati, for 2 weeks.
No, kindly dispose it of, my lord. It won't take a minutes.
The governance please to make the following department order number so and so the classification. 191 is this order of 16th of November 2022.
My lord.
That was on the challenge on various legal grounds.
All right.
Now they accept this. They say they have reverted.
Now, where is that?
My lord, kindly see, my lord, my affidavit in opposition, page 9.
They have reverted back to page 188 position.
Yes.
They have reverted back to page 188 position.
Page 9, my lord.
That is all that they say.
Let me see the affidavit, sir.
Affidavit দেওয়া আছে তো কেন দেয়নি
And
অরিজিনাল তো দিয়ে দিয়েছি তো
and they are taking steps to act in accordance with law.
in item number 24 এ দেখুন 24
Where is the affidavit?
24 এ দেখুন
Affidavit in opposition,
yes,
Secretary Department.
the first page.
Page
9, my lord, only in 24, my lord, it has
24.
affidavit in opposition in, my lord, item number 24.
Page 9.
Page 9. No, no.
Item 24, page 9.
In supersession to this department order number 1611/2022 regarding risk-based classification of building, it is hereby notified that the online building plan approval system shall be reverted to this department's order
Yes.
number so and so dated 19th February 2020, after 2 days from date of issue of this order till further order. Nothing is left.
Exactly, nothing remains. But it says still further orders, they may revive it at any moment. After
So then you come again if they revive it.
finally give the liberty dispose. Give the liberty and dispose.
Keep the points open.
এটা তো করা উচিত ছিল আমরা কন্টেস্ট না করে রিভার্ট করে দিল কেন ভালো
The petitioner in the present writ petition had challenged the impugn order dated 16/11/2022, published in the official gazette dated 20th February 2023. Full stop. Learned counsel for the respondent has filed. Respondent number 2 has filed his affidavit in opposition, wherein he has annexed the order dated 12/9/2023, where order number 696/MA/O/C-4/1, ये यहाँ से लो, dated so and so, page 9. Order dated so and so, dated so and so. Order number so and so, dated so and so. Wherein it is stated that in supersession to the department's order dated, ये यहाँ से लेना, 60 down. It is hereby notified the online, ठीक है, shall be served यहाँ से यहाँ तक, tick to tick, ठीक है. In view of the said statement, nothing survives in the present writ petition. The petitioner seeks liberty to approach this court in case the department reverses or passes any order which will prejudice the interest of the petitioner. Full stop. This court, needless to state, the petitioner is always at liberty to file appropriate proceedings in accordance with law. With the above direction, the present writ petitions are disposed of. All writ petitions?
Yes, yes, all 23 to 31.
23 to 31. Yeah. बस हो गया उसमें एक लाइन डाल देना in view of the said I'll just add one line in view of the said notification. Yes, nothing survives in the present writ petition. The petitioner seeks to withdraw the present writ petition with liberty to challenge the same. Yes, with liberty to challenge if the situation changes, with liberty to avail with liberty to file appropriate proceedings in accordance with law.
If situation changes.
I will contact you. Thank you.